call the list.
My lord, today is not the date of mentioning. Yes, my lord, in utter desperation, I have come before your lordship. There is, every time there is communication gap. On 23rd of June, your lordship came up in your lordship's list. And thereafter, your lordship was pleased to direct the matter will appear before your lordship. But the fact remains there is communication gap all the time that it cannot be heard by this bench. It was directed by the review. I don't think that's original.
What, Mr. Chakraborty? What do you want?
My lord, I want the matter be placed before the list for hearing, my lord.
It will be done so. Yesterday also you
My
mentioned.
lord,
You yesterday mentioned also.
yesterday, day before yesterday,
Mr. Chakraborty, it will come in the combined list.
my lord,
It will come in the combined list.
my lord.
Please hand over this thing.
May I seek your lordship's leave to file this appeal?
An advocate is standing beside you. You don't have the first audience. Allow the advocates to complete their narrative.
May I have my lord's kind leave, my lord, to mention one original side matter, my lord, for inclusion as to be mentioned, because my lord, the matter has been wrongly filed before your lordships. My lord, this matter pertains to a Group 6 matter, my lord, relatable to my lord, some staffs of this honorable court. So, my lord, the matter should have been filed, my lord, before the Honorable Chief Justice, because my lord, the determination is now, my lord, there is a bifurcation in the determination. My lords are having, my lord, determination pertaining to Group 6 appeals, which are not relatable to High Court staffs.
Yes.
Well, that is what is indicated in the list. My lord, wrongly, my lord, the appeal has been filed before your lordships. If my lords kindly, my lord, allow this matter
Then
to.
send it down. Any formal order is
My lord, I need to, my lord, correct, my lord, the presentation form as well, my lord, as per my lord's kind leave. My lord, in the
মানে রিলিজ করে দিতে হবে নতুন একটা।
form also, my lord, Friday is the returnable date indicated. I will again inform, my lord, I have served, I will again inform.
অরিজিনাল সাইডের ওকে ডেকে নোট করে নাও।
So grateful to your lordships, friends. Great.
When was it filed?
3-4 days back.
It will appear Friday 2 p.m. You inform me or
I will definitely, my lord, inform.
Call.
So grateful.
Yes, what is your problem?
I am the applicant in person, my lord. And may I seek your lordship's leave to file this appeal with the server copy of the order, because 2 times I applied for the certified copy, and since
When was the order passed? When was the order passed?
17th of May 2023, and since after the second attempt, my lord,
File the second application for certified.
second application is 7th August.
দিয়ে দাও, leave দিয়ে দাও। Leave granted. Yes, call the list.
Gratefully. Gratefully, your lordship.
My lords, in this matter, Mr. Sarvajan is appearing for the petitioner. My lords, in this matter, Mr. Sarvajan is appearing for the petitioner. He is on legs in court number 18. I am paying for 1 day accommodation, my lord.
Cannot be 1 day. It will go in the monthly list of monthly list now. What order did he? Yes, what happened to your yes, Mr.
Yes, I am.
Your report is already
Report is already there.
Huh?
Report is already there.
Earlier report or any new report you have filed?
No, not new report. On the earlier occasion, my lord, before the Honorable Chief Justice, my lord, I filed the report already. And
Your stand is the person is Bangladeshi national.
Bangladeshi Nagar. Everything has been detailed therein, and not only that, your lordship will find that pursuant to the order of Honorable the Division Bench of Honorable Justice Kalyan Jyoti Sengupta,
Huh.
Ministry of External Affairs, they already had contact with the Ministry of External Affairs of Bangladesh. And already a report was filed in seal cover before this honorable court. Reports are already there. So therefore, now the question is that if the citizen is at all a citizen of Bangladesh, naturally we have no liability. We cannot do anything.
An adjournment has been prayed for on behalf of the petitioner. Stop. On behalf of the petitioner, though Mr. Chatterjee, Mr. Chatterjee, learned advocate appearing for the
Respondents, Union of India, and
Union of India,
India and Border Security Force.
who are they?
They had to file the report, my lord, so therefore.
Appearing for Union of India and appearing for the respondent numbers 1 to 4 and 12. And Mr. Kobil, learned advocate appearing for the state are present. List the matter for further consideration on 26th September. Please come, Mr. Chatterjee, please be present on 26th. We will dispose it of.
Yes. I have, my lord, due to my illness, I could not come on the last of the summer.
Yes, next.
Should I beg to appear on behalf of the state?
Yeah.
My lord, in this matter, I am appearing on behalf of the state.
Who is
My lord, the
Mr.
final report
Muteshwar
was
Maiti?
already filed. The case of drowning, my lord.
Where is Mr. Maiti? Muteshwar Maiti?
Last occasion, we filed the report and your lordship,
You gave final report copy?
yes,
you gave?
yes, my lord. Copy was submitted before your lordship.
Yes,
But
Mr.
he-
Maiti, you have got the final report.
Lord, I gone through this, my lord. Some discrepancies is there.
Yes, tell us what is the discrepancy.
Lord, in second paragraph, in course of investigation.
এই রিপোর্টটা দেখ না
হুম।
এই রিপোর্টটা দেখ তো।
My lord, I drawing lordship's attention, 1, 2, 3, 4, 5 line. With an delay, the said Surojit Shah was contacted and it would be learned that he had already left Calcutta on 4/9/2099 on an alleged commission of offense held on 2/9/99. Got your lordships?
It is not 2999, it is 2000.
The incidents happened
19.
2019. It happened.
19.
Yes,
He was an employee of such and such. Further inquiry also revealed that Surojit Shah was present with missing person, Akash Ghosh on 2/9/99 up to 23:30 hours. Accordingly, the said person Surojit Shah was called at Bortala PS, and after examining him, it could be learned that on 2/9/99. There is no whisper when said Surojit was called for in the PS. The incidents happened 2/9/99.
19.
19.
Sorry, my lord, 19. My lord, the
কবে 164
incidents happened, my lord, 2/9/19, and my lord, the Ashok Ghosh left the place on 4/9/90. That's my lord, who was the used to reside somewhere, sir, my lord, thereafter, my lord.
No, Surojit's statement was recorded.
Yes.
That's true. Mere recording mere statement recording, that's not the all person, since my lord, the
You are
person,
absolutely right, but
my
Mr.
the person dead body has not yet been recovered. My question is, my lord, from the very beginning, the police authority showing the dead body, intention on showing the dead body, nowhere
In the dead body, DNA profile did not match.
that is long after. That is long after.
No, the incident was that it
Incident-
happened in 2019. Subsequently, a dead body was recovered. So it was shown to you, you denied that it is not my son. So they conducted DNA profiling of the body, that is the tooth, I think, along with your blood samples and everything.
That has been tested and
And it
negative.
was found that that is not your son's body.
Yes, correct.
Right. Now
That is held Indian 2021 or 19. That is 21.
Mr. Maiti, that can be considered in the regular proceeding. How can habeas
No,
corpus?
my responsible submission to this question. What I am come before lordships.
We understand your anxiety. We understand your anxiety.
From the
but
very
Mr.
beginning, the complaint has been raised that only 2 persons are well acquainted with her
Right,
aim,
right. You are
and
absolutely,
person should be, my lord, checked it off.
no, you are
Only
absolutely,
164 statement merely cannot do help.
exactly. So you are, now your grievance should be against the final report.
Final
We
rep-
sitting in habeas corpus, we cannot decide the.
No, my lord, if your lordship kindly appreciate final report, what's end? They have been submitted the final report. What is final report? The investigation completed? No, sir, no, kindly appreciate to that. Is it final report?
Final report was filed on 15th.
No, that is another point.
Subsection A.
No, that is other points, my lord. Today, my lord, this matter, when I come before this court, my lord, for habeas corpus, then the second investigation started, and that report is come before this court, investigation completed, we have nothing to see. Since 4 years back, incidents happened.
My lord,
This is the final report.
Keep quiet, Mr. Chair, we will call upon you.
my lord,
Acha, where is the final report?
my lord, final report was filed on 15th July 2023 before the learned Chief Metropolitan Magistrate, Calcutta,
15th July.
2023. The person who was with the missing person at that time, his 164 statement was taken, my lord. He stated after taking alcohol, they went to
Have a bath.
have a bath at River Ganga. Thereafter, this is a pure case of drowning, my lord. Huh?
Stated in 164 that he came up from that campus. This so far my responsible submission to this case, my lord.
Subrata Kundu,
Subrata
164 is of one Surajit Sahu.
Surajit Sahu and another lady, my lord,
Pujabar.
who had a love relationship with that person. He had a talk.
Subrata Kundu,
Subrata Kundu. কোথায় সুব্রত কুন্ডু?
এই যে এইখানে স্বপনের
না না এটা
and did you record statement of Puja Bodal?
Yes, my lord, under section 164 before the
Where is
magistrate.
that?
In the previous report, we submitted.
In the previous report, we have submitted, my lord. My lord, in this report also, my lord, kindly see second page, second paragraph. Surojit and Pooja rendered their confidential statement under section 164 of CRPC.
And my lord, Lord, passing the order. Lord, may I submit one thing?
Yes, yes.
Lord, this has come before this my legal aid, legal aid authority. I come. This is just my responsible submission. The person who has lodged the complaint, she was prevented various ways by the police authorities. That's why the person came before the my lord legal aid authority. It is a very vital thing. My submission itself the police authority was silent for long 4 years. When the complaint has been, specific complaint was made, the person has been missing. What steps has been taken for the missing? If it is there not found, that the missing squad is there, they have approached before this specific way, not the formal way.
Acha, when did you find the body?
That body was found in 2021.
On 4th of September in respect of another unnatural death.
Unnatural death case.
And when did you call them for forensic examination?
Just after that is 2021.
My lord, just after recovery of the dead body.
1st July 2021.
21, my lord.
1st July 2021. An incident happened, my lord, 19.
তারপর forensic report এসেছে 20 যেটা এসেছে, করেছে
Yes, case was lodged on.
Miss 23
So far, my instruction from my client, my lord, the person still, my lord, alive in the hidden place by these said two persons against whom the complaint has been lodged. Merely statement, the 164 statement will not do, my lord. This is the first beginning, the complaint has been lodged by the client. And it is the very peculiar things, my lord. When the police authority not render the assistance, then it came before the legal authority.
My lord, immediately thereafter, case has been started under section 363 of the Indian Penal Code in the year of 2019.
Did you arrest anybody?
No, my lord, there is
Nothing.
no. They voluntarily went there for taking bath.
Yes.
That is the version of a person who made the 164 statement.
FIR was lodged.
And the implicated lady has knocked the door of this court, knocked the door of this court with a prayer for issue of the writ of habeas corpus to get back his son. On 4th September 2019, it was reported to Bortola PS that the petitioner's son, namely Rana Ghosh, alias Akash, went missing on 2nd September 2019. The said information was diarized as Bortola PS. Ole Bortola, BUR, yes, 270 dated 4th September 2021. On 6th September, the petitioner again made a complaint that and her. But the said DNA, those DNA profiles didn't match.
Copy নেই? এটা পড়ো, পড়ো, পড়ো।
And the forensic report came out with a finding that the petitioners and her husband are not the biological parents of the person whose body was found within the jurisdiction of South.
এটা করো, রিপোর্ট দেখো। দেখেনি কোন পেয়েছে? এই ক্লার্ক এখন কালকে দিয়েছিল, লিখেছি মানে কালকে দিয়েছি।
Whereabouts of the petitioner's son could not be traced despite of lapse of considerable period of time. The petitioner has been constant to approach this court. Start stop it. Pursuant to our earlier order, Mr. Chatterjee, the letter requesting the state submitted report prepared by the OC Bortola PS from Kolkata, and that report was handed over to Mr. Maitri for perusal and to make the deliberation of the Mr. Maitri Lanet advocate representing the petitioner submitted that there is many contradiction and anomaly in the report. He submits that there is no indication when the statement of Surojit Sahu was recorded, and he asserts that the petitioner's son is still alive and he is keeping and he has been illegally detained, and he approached this court for passing the case order to transfer the investigation to any other agency. The Hon'ble advocate perused the materials placed before us
ও তাড়াতাড়ি টাইমে কি করে ফেলেছে?
from the report. It transpires that in connection with Bortola PS case number 144 of 2019, the investigation was conducted and the statement of Surojit Sahu and Pooja Boral were recorded under section 164 CRPC, and the information was given in the missing person square, Lal Bazar, and several reminder was also given to find the whereabouts of the petitioner's son. And even the missing information of petitioner's son was published in well circulated newspaper on several occasions, newspapers on several occasions. And ultimately, the investigating officer from we shall get that final report has been filed.
My lords,
Final report shall be submitted where from?
my lord, kindly see third page, last page of the report. It was submitted before the learned additional chief metropolitan magistrate on 15th July 2023. Final report number 33 of 2023, dated
And
for
we are informed that the investigating officer has already completed his investigation and submitted final report by number 5. FRMF,
final report number 33 of 2000.
FRMF,
FRMF, my lord.
Mistake of fact.
Mistake of facts.
FRMF
Number 33
number 33
of 2023,
of 2023.
dated 14th July 2023.
Has been filed. Before the court of learned chief
Additional Chief Metropolitan Magistrate, Calcutta.
additional chief metropolitan magistrate, Kolkata. So, in such sequence of fact, we didn't find any material to infer the petitioner's son has been illegally detained. And as such, no further interference is called for in this petition of the same is accordingly dismissed. However, it is clarified that this order shall not preclude the petitioner from taking appropriate steps in accordance with law before the appropriate court.
Disposed of.
Grateful, Magistrate. Hello, in this matter, I am appearing on behalf of the state. Well, on last occasion, on 9th August 2023, my lord, on last occasion, on last occasion when the matter was called on, my lord, on 9th August 2023, no one appeared on behalf of the petitioner, my lord. Although in this case, the minor victim girl was recovered and his medical examination was done, 164 statement was taken, and now he is in child welfare home at Malda.
Where do we find that?
My lord, report has already been submitted on last occasion. I have a
report was of 18th July. Any further report you find?
my lord, on 9th
of
August,
we
the
don't have
report was
that.
filed, report dated 27th.
We have only one report.
I have
That is of
a
18th of
copy,
June.
my lord, if your lordship kindly permit, my lord. I have a no, no. Oh, you can take copy. Annexures are there, my lord.
None appears on behalf of the petitioner. And no. Record reveals that none appears to represent the petitioner on 9/8/2023 when the matter was last taken up for hearing. Today also none appears on behalf of the petitioner and no accommodation has been sought for. So Mr. Chakraborty learned additional public person is present to represent the state. So, from the report as placed by Mr. Chatterjee, it appears that the victim lady has already been recovered, and the statement of the victim lady has been recorded under section 164 CRPC in connection with Harish Chandra PS case number 616 of 2023, dated 1st July 2023, under section 364/365, 365 items. And we are informed that the victim lady is now lying under the custody of Child Welfare Committee, Malda.
Malda, my lord. Child welfare home, Malda.
And see, the victim lady, the lady is present lying under the custody.
What?
Child Welfare Committee, Malda,
Malda, my lord.
and lying in home, which home?
My lord, child home at Malda. It was stated in the report.
And
And
staying.
residing in a safe home. ঠিক আছে? Residing in a safe home.
My lord, as per the order of the Child Welfare Committee,
In view of
Get the report as file.
let the report as filed. You do one thing, you
my lord, this is my copy, my lord. I am praying apology, my lord. Last,
get a photocopy.
my lord, my lord. In course of the day, I will-
It was a report as placed as a are kept on record, it's taken on record. ঠিক আছে? হ্যাঁ, in view thereof, the requisition is disposed of.
In theory, the evidence is called.
This is called for that is petition stand disposed.
Yes, next.
it's something right.
এটা আমাকে দ্রুত জেরক্স করে ওটা চাপা দিয়ে জেরক্স করতে হবে।
এইটা একটা,
My lord, I am for the petitioner, my lord.
My lord, in this matter, I am appearing on behalf of the state, my lord. The action of the police and the investigation is appreciable, my lord. Last occasion, their lordships were pleased to direct me. Your lordship desire was cover the, yes, my lord.
He covered
And the-
where she is staying.
Accused person also brought under custody from arrest from Haryana. Now he is living child welfare home at Purbo Bardhaman by the order of the Child Welfare Committee, Paschim Bardhaman. And accused is in judicial custody. Yes, my. আবার চলছে তোমাদের।
এই আপু Hard Mr. Sachansar,
Your name?
Kuntal Banerjee, my lord.
Bennett. Hard Mr. Bansi Lanet Advocate appearing.
appealing for the petitioner and Chatterjee landed appealing for the state.
Additional public.
So, Mr. Chatterjee submit the victim.
किया जाता
Why not? The victim lady has already been recovered.
এইগুলোতে
And
presently in a safe.
and on the basis of the order passed by the Child Welfare Committee, Paschim Medinipur,
Paschim Bardhaman.
Paschim Bardhaman,
She was placed before
On the basis
Child-
of the order of the Child Welfare Committee,
Paschim Bardhaman.
Bardhaman,
Now she is staying at Child Welfare Home, Purbo Bardhaman.
he is staying in a child.
একবার রিপোর্টটা দাও।
Purbo Bardhaman. ঠিক আছে?
as per she is presently staying.
Now on the basis of the order passed by the Child Welfare Committee.
পূর্ব বর্ধমান।
পূর্ব বর্ধমান?
Yes.
পূর্ব। Child Welfare Committee পূর্ব বর্ধমান
Order was passed by the Child Welfare Committee, Paschim Bardhaman. My lord, kindly see second last paragraph.
পশ্চিম
রানীগঞ্জ তো পশ্চিম বর্ধমান।
which is the order passed by the Child Welfare পশ্চিম বর্ধমান।
Second last paragraph of the report.
Saying, আচ্ছা, in
And
the
provision of POXO Act has been added.
TWC
পূর্ব বর্ধমান। Children's Home for Girls, পূর্ব বর্ধমান। ঠিক আছে? হ্যাঁ।
submitted picture.
She is saying the Children's Home for Girls, পূর্ব বর্ধমান। And her statement has also been recorded under section 164 CRPC in connection with the Raniganj PS case number 230 of 2023. Stop. The report as placed by Mr. Chatterjee is taken on record. Because in view of such factors circumstances, no interference is called for in the repetition. Secondly, the repetition can be withdrawn.
My lord, item number 5, Mr. Doipayan Kundu is appearing for the petition. My lord, I'm playing for very short pass. He's in court room number 29. This matter at the time of COVID.
Where is he?
My lord, court room number 29. He's on his legs, my lord. Matter is being very short pass.
Pass over.
My lord,
Pass
my lord,
over.
kindly make not today, my lord. Kindly, my lord.
What happened? Final report filed.
Yes, my lord. Nothing is there, my lord. I leave it up to your lordship.
Come tomorrow. Come.
Great. People.
Six.
And 6, your lordship may
Six
remember.
and 7, both are analogous. Malar 6, malar I am appearing with Mr. Somo Mujumdar. 7 is my London senior friend is appearing. This is a land loser matter, my lord. Happen.
6, your lordship may remember on the last occasion, I mean
Yes,
initially,
Mr. Bhattacharya, what-
I have already said once, my lord.
My lord,
They
I
will
am
come
again-
with the, I have conveyed your lordship's observation to them, my lord, the officers. I have asked them, if you want to file affidavit in opposition, you have to come with the solid convincing document, my lord. We are supposed to sit with them, my lord, tomorrow. Your lordship, can you take this matter on Monday? I shall come.
It cannot be on Monday then. It has to, because I won't be there. The circuit bench is there.
My lord, what happened? May I submit one thing? They filed objection before the learned tribunal.
Sure.
They have disclosed their stand that we are not responsible, Fed corridor is responsible. Now, when the original order direction was given, their parties, that direction was not challenged. First of all. Secondly, if your lordship finds that land was acquired by the central government, not by the Fed corridor.
Right, Mr. Datta, we remember, we are making an attempt so that
Yes,
the
yes,
problem
yes,
can
yes.
be solved.
I am
And
on,
lordship
If-
kindly
if he
consider
comes-
that now they cannot escape their liability.
I am on.
That is an argument on merit, Mr. Datta.
Yes.
We requested Mr. Bhattacharya to take a stand that, because yesterday also another matter appeared. In that matter, the person, similar conversation was held. He came and said, all right, we are conducting the physical efficiency test, we will call the person. And as such, we directed him to file a status report before us, whether what steps have been taken. So if Mr. Bhattacharya fails, we hear it out on merit.
Yes.
We'll argue on that. But if the positive result comes, then we will direct
No,
him
he
to-
says that he will convince your lordship that their stand is correct.
No, that he has not argued. We have not heard you also on that.
I have said, I have conveyed my lord's observation.
Mr. Bhattacharya, as we have shared the inputs with you,
Yeah.
if you tell them that you come with an affidavit, they will never.
No, I have, your lordship's observation, you convincing material, if not there, you have to give consent to the order passed by this
No,
honorable.
yesterday we passed an order wherein the railways agreed that we are conducting the test, we will call them.
Man,
As such, we have
here,
asked
my
for
lord,
a-
They have specifically stated on the first sitting, my lord, they have something to say. That is why I have come with the documents. What is your stand? Otherwise, I cannot convince the court, my lord. That is why tomorrow we'll sit with them.
My lord, he now,
It will take a day after tomorrow.
we have to,
Monday problem.
we have to,
Yeah,
lordship,
yeah,
what-
just one. যে আমরা status combined list এর 57 থেকে combined list এর 57 থেকে 64
তখন আমার
পাঁচটা রেডি
day after tomorrow.
clearly of the sound.
এরও নয়। Mr. Bhattacharya, we are not asking you to file affidavit. We have passed directions in similar matters, not in respect of Southeastern. You are for Southeastern.
Eastern Railway.
Eastern Railway.
Eastern. In respect of the other group, we have called for a status report as to whether they have been called or not. They said that they will be called, and that we have fixed on 18th of September.
My lord, what
Your
happened?
lordship, then in that event, your lordship can file, direct this matter to appear on 18th of September. But the similar order cannot be. But in this case, but in this case, what I submit before your lordship, my lord, the initial, well, I tell your lordship, the initial order.
Lordship, may I submit one
Well,
thing?
I tell your lordship, like hints, the first order when was passed against my lord railway, in
Mr.
that,
Bhattacharya, we do not want any controversy. You cannot now take a pick and choose at it. That one railway will comply, we will not comply. This is nothing but a dilatory tactics which is
no, man,
adopted.
this is, your lordship will not take it that way. Man, I personally want, when I applied my mind.
It a 12 তারিখ রাখো. On 12th, it will be there.
My
We are
lord,
not
I will
calling
come
for
with-
any evidence. We are not, because if the admitted documents are
Yes.
here, question of
There,
affidavit has-
I cannot pray for affidavit.
Yes, Mr. Datta.
my lord, I was just saying, my lord, in this case, they are not
Have
Called
patience,
for-
Mr. Datta, have patience.
No, called for screening also.
Screening, they have not yet scheduled the date.
No. Others, they have screened already.
Patience from.
That's why the learned tribunal held that they have initiated the process by screening, so we are dropping the proceeding. In our case, only 2 cases, they have not screened even, they are saying you will be screened by the freight corridor. We will not screen you.
I tell your lordship,
We will not screen you.
what my,
Because we are not responsible. It was acquired for the special project of freight corridor, so that company will screen you. Our sense,
It has been decided.
no, that is their point in the opposition.
In every point, they are just.
That has been decided, no? They
No,
cannot-
because, no,
Lordship.
not decided
but
because
that
of the
point
fact, because of the fact, my lord, they have taken this point in before the learned tribunal and tribunal did not consider. That is the valid point. Now, again, their stand is that we will not do it.
So, Mr. Datta, what do you want?
They should do it.
No. So
Railway
for
is a
doing, there has to be an adjudication, no?
Yes.
We have to hear you, we have to hear them.
Well, let there be a direction for affidavit.
No.
No,
No
already
evidence.
stand was disclosed before the learned tribunal.
Mr. Bhattacharya, you come with that status report.
Let there
Come
be.
with that status.
If he sits with tomorrow, my lord, day after tomorrow, lordship, kindly
your
consider.
lordship kindly pass an order with regard to
They
status
are-
report, and that will be also helpful for me, my lord. The respondent are directed to come with the status report on the next set of hearing.
Are if you have not called them, what status report will file? If your stand is that we will not call them, what status report you will file? We are not calling for affidavits, we will finally dispose of on that. No further affidavit. If we are satisfied with Mr. Datta's
And
contribution,
also, I mean, after hearing.
that is the stand already there and that was considered, then question of further affidavit does not occasion.
And your lordship kindly consider, my lord, in the initial order, only railway was the party. Subsequently, they filed contempt application, they added.
No. Initial order also.
Only railway was party.
Lordship, kindly see the initial order.
Initial order also.
Deliberate for corridor over the party.
Hey,
Yes, first order we are the party.
আমার কাছে যা কষ্ট টাইটেল আছে
আপনি দেখেন।
আমি দেখাবো
If that be so, my lord, railway is responsible. If railway was the only party.
কোথা থেকে ফ্রেড কর্পোরেশন এলো সেটাই তো কিচ্ছু ঘাঁটি
অর্ডারটা প্রথম তো দেখি।
আপনার ম্যাটারে না।
আপনার ম্যাটার নয়, আপনি বুঝতে পারবেন।
excusing the stand বললে ওই stand নিয়ে।
ওইটা না এটা ফাইনাল
By an earlier order dated 17th August 2023, we directed Mr. Bhattacharya, learned advocate appearing for the respondent numbers 1, 2, and 4 to avail necessary instruction and apprise this court about the to avail necessary instruction. Stop. Today, Mr. Bhattacharya prays for extension of time. Prays for extension of time to apprise this court about the stand of the railways. Apprise this court as regards the people. Today, Mr. Bhattacharya today, Mr. Bhattacharya submits that he has not yet availed necessary instruction from the concerned respondents. Stop. As a last chance, comma, the matter stands adjourned. List the matter for further consideration in the daily supplementary list on 12th of September.
না দিতে বলছি
সব জয় অবশ্যই ঘটছে
বল বল
For my satisfaction,
It is made clear that in the event proper instruction is not furnished to Mr. Bhattacharya, in the meantime, comma, this court would be constrained to direct personal appearance of the concerned official. Stop. Concerned officer. Stop. It is court. 12 তারিখ করে।
বল কি বল
for my satisfaction, may I submit one?
For your satisfaction,
Twofold submission, man.
you are for whom?
I am for.
He is the advocate on record.
For serial number 6, my lord.
6 and 7.
May I submit for two submissions, my lord. My lord, 16 March 2020, there is an order passed by the Honorable Tribunal. My lord, my background of this case, my lord, in West Bengal, there is a 6 or 7 project is there. Some project is managed by the Southeastern Railway, some project managed by the Eastern Railway. And the 16 March 2020, all the projects has been analogously heard and disposed of this tribunal. They are the party. Only Southeastern Railway challenge picked up the 2 original application and challenged the tribunal order before this honorable court. Honorable Justice Soumensen presided over another justice, my lord, dismissed their contention. The Eastern Railway Authority not challenged this order on 16 March 2020. Now, when the contempt proceedings is filed, they cannot change their stand, my lord. That order is already upheld.
That will be the final order, Mr.
Final order.
Chatterjee.
or that adjudication is required সেই জন্যই তো জজ give him some time to come with instruction, proper instruction.
If by virtue of this order, they decide in the conspectus of facts that they would call you, and if that recording is endorsed by this court, then it will be better for you. Instead of going into an adversarial litigation. That is because we are reposing faith upon Mr. Bhattacharya. Now, if he comes and says that, no, my stand, I will stick to it, we will finally
9 and
decide.
10 years we are fighting, that's why agony. my lord.
But you are fighting before us for at least
Oh, well,
15 days.
No, my lord, before from tribunal to high court.
So it is not our fault. You are
These
fighting
matters
before
came
us
before
and
this
we are
on
making an
Honorable High Court.
endeavor. We are making an endeavor so that you are called for this screening. This is our endeavor. Your officer should not. And if he still decides, we will approve, because if this is true, that the original order where the stand was taken, a coordinate bench has already rejected that, then the issue cannot be reopened, Mr. Bhattacharya, subject to hearing. Yes, next. Next tateও কি same order?
Seven is same.
Same appearances.
Same.
Mr. Bhattacharya,
No.
they are in the other.
Same.
Lawyers সাথে
6 and
6 and 7. What is
6 and
8?
7.
What is 8?
I am for the petition.
Which railway?
This is the Southeastern.
Mr. Bhattacharya.
I mentioned this matter on Monday. This matter have been fixed on 18 September.
This has already been fixed on 18 September.
September. I mentioned on Monday.
Application, Your Lordship directed.
Yes,
to
yes, sir. My,
appeal.
he was mentioning on,
Status report in
Sure.
respect of analogous matters we directed. এইটা 18 সেপ্টেম্বর ওই চারটে ম্যাটারের সাথে রেখে দেবে। কম্বাইন লিস্টের যে
Mention
পাঁচটা matter,
Yes, করেছি।
8 নম্বর
ওর একটা পয়সা পাবি আমি পাবো।
এটা নাকি সে যে কথা হয়েছিল বলছে
was-
ও ছিল না তো। Your junior was there,
Yes,
you were not there on this.
I know that.
এইটাকে 18 18th we have kept 18th
18 September.
18th
আমাদেরটা তো
yes, solve
আমাদের
ডাকু কম্বাইন লিস্ট আবার 9 10 এর মাথাটা খারাপ হয়ে গেছে, বয়স হয়ে গেছে মাথাটা। দেখি কম্বাইন লিস্টটা দেওয়া yes Mr. Koti.
And this is an application for extension of interim order.
183.
186
My lord, Mr. Ashwin Kumar Raut is appearing for the respondent, but he is engaged in another court. He is coming, my lord.
application filed prior to expiry.
Yes, Lord, in fact, it was also mentioned subsequently, but because Lord Justice Talukdar was retiring, Lord, could not be taken.
What is the interim order?
Lord, the interim order is, Lord, I tell your Lordship, this is a service matter in which, Lord, a dismissed employee had challenged by way of a writ petition, the order of dismissal. Now, Lord, the learned judge, Lord, upheld a portion of the challenge in the sense that the learned judge held that there was violation of principles of natural justice in respect of not allowing a particular witness, being witness number 5, PW5, not being cross-examined. That's one aspect. The other aspect was that, Lord, the inquiry officer, or rather the presiding officer, should have summoned some of the witnesses on behalf of the respondent. These are the two main grounds on which, Lord, the writ petition succeeded. And Lord, the matter was remanded back to the stage from where the dismissal order, Lord, emanated. Now, Lord, we preferred an appeal, and the appeal court has stayed that order. That was an interim order, stayed, Lord, on contest. If your Lordships looks at the order of 18th January 2023, your Lordships will get the fair view of the matter.
18th January.
Yes, Lord, 18th January 2023, when the first order of stay was passed. Your Lordships can take the application, page 9, or otherwise also.
Where is Ashim Raut?
My lord, he is in his legs before court number 35, my lord. He'll come, my lord.
Mr. Kor, short password.
As your Lordship pleases, or can
When
you?
he will come, when he will.
My lord,
All right, we keep it at 2 p.m. Ask him to come.
my lord, I'm praying for just a short Passover. my lord.
When is the interim order expiring?
Lord, it expired, Lord, on end of June 2023. That is 30th of June 2023. It has expired.
Yes,
My lord, kindly give a short Passover. He'll just,
Mr. Kor, we give him a short.
Kindly keep it at 2 o'clock, Lord. We'll come back
my lord,
because
2
instead of
2 o'clock, another matter is fixed. My lord, before court number 4, my lord.
So you tell us he will be kept waiting. When he will come here to continue to stay?
My lord, I'm telling him,
The senior counsel, he has other engagement.
okay, my
So
lord.
you tell us a time, we will keep it.
keep it at 1 o'clock. I'll come back at 1 o'clock.
Yes, ma'am. Yes, ma'am.
1 o'clock.
Yes, ma'am. Grateful.
Please tell Mr.
Yes,
Rao.
my lord, I'm telling him.
Much okay.
এটা পাসওয়ার্ড করে রাখো, হ্যাঁ কি খবর পেলে? আচ্ছা তাহলে শুক্রবার 2টোর সময় দিয়ে দাও। তুমি মেনশন। আর কোনো ছোট মামলা আছে আমাদের? সেটা তো ঠিক আছে তো। পাসওয়ার্ডটা রাখলে 187
ঠিক আছে যাও।
you're for the apple.
নতুন এসছে।
What is the can application?
Lordship, that must be a stay application, Lordship.
It's an application for stay. But on the last occasion, my lords have been pleased to admit the appeal and directed for exchange of affidavits. But no affidavit is forthcoming, but I think, my lord, that is not necessary. But all the affidavits in opposition and replies are on record.
Yes, what do you say?
What my learned friend saying is very correct, but still in this matter, Lordship, we would like to rely on 3 more documents. And we could not prepare the affidavit, Lordship, within time. It's a long time, Lordship. It's a laches on our part, Lordship. If your
was
Lordship,
given 23rd
I know,
September.
Lordship, it was.
What is the issue?
Lordship, the
issue is
issue
a
is
pension.
pension, whether he opted for the pension or not. Now, I said he has not opted for the pension. I would like to show from 2-3 collateral documents that he has never opted for the pension. Because pension is an option you have to exercise, Lordship. So he has not exercised that, because the point of time it was supposed to be exercised, pension was not very lucrative, because the retirement benefit and the interest on the same was quite high. Now the scenario has changed because of the drop in the bank rate. So we are facing many litigations like that we opted and now we are not getting. So Lordship, to show that, to demonstrate that, I would request your Lordship to allow me 2 weeks' time. I will place a short affidavit, not a short affidavit, further few documents, so that I can demonstrate that he has never opted for. This is the short issue, Lordship. He has opted or
What
not
did the
opted.
trial judge hold?
Yes. But the trial judge says, I have not opted for the pension. They have relied on a document, but which itself is a fictitious document. But I have challenged my,
Trial judge held against you that you have not exercised.
yes. And will are a disputed question of facts, therefore the writ petition is not maintained.
Ashok, Mr. Banerjee learned advocate appearing for the respondent number 2.
Lordship, I am appearing on the respondent number 8, CMPF, Coal Mines Provident Fund. In this matter.
You are not, do you want to file affidavit?
My lord, the
No,
Coal
no, no.
Mines Provident Fund actually fought the matter in the before the single judge, honorable single judge. My lord, the employer kept mum, though filed the my lord, the affidavit in
Why
opposition.
haven't you filed he has filed the opposition?
Yes, opposition reply, everything has been exchanged.
No, that is in the writ petition.
Yes,
Not in appeal.
Not the appeal.
You don't want
Lordship,
to file affidavit?
Last occasion, Lordship give me direction. If you want to file,
that-
then you can file it. Otherwise, not required.
আচ্ছা, ঠিক আছে।
If your Lordship can give me
We-
direction to file affidavits, then I,
Learned advocates appearing for the respective respondents.
number 8, Lordship.
Pray for a short extension of time to file the affidavit in opposition. As a last chance, উপরে লিখে দিও heard Mr. Das, learned advocate appearing for the action.
But it's a long pending matter, my lord, he is.
What order we have. As a last chance, the time to file the affidavit in opposition is extended for a week from date.
Man,
At least kindly 2 weeks, Lordship, because as you know, my
Weeks
government.
from date, reply thereto if any be filed within a week thereafter. Please the matter as for orders in the daily supplementary list of this court on. সুরজিৎ নেই আজকে এই পর্যন্ত।
Lordship, I will be out of country from 11th to 18th for an academic reason, Lordship. 11th to 18th of next month, any day before or after that.
On 20th September.
Obliged, Lordship, much obliged.
no, 20th September, there is one, another fixed matter is there. My lord, kindly keeps it on 21st.
Which
Oh,
fixed matter is
20th হলে তো 20th বুধবার। Very well, my lord, let it be on the list. Let it be in the list.
Thank you. I'm okay.
ছেড়ে দিলে আর হবে না।
Hello, I'm appearing on behalf of the appellant. I'm led by Mr. Punit Bag. He's on legs. I'm praying for a short passover.
Not today.
My lord, can it be fixed on any other?
Sorry. It will come on rotation. You will not get an early chance.
But 189, my lord, I am for the respondent, my lord.
I am for the petition.
Petition. What are the applications about? Stay
There
application,
are
Yes.
there are
One-
two applications. One is my lord, section 5.
section 5.
Five.
How many days?
231 days delay. Why, my lord? The earlier in the trial code, Mr. Partho Sarkar, this is my change brief. In the trial code, Mr. Partho Sarkar moved this writ application. Well, he taken after disposed of the application by the learned trial court, he taken major road accident with his family member.
Oh,
And my lord, near about 2.5 years, my lord, she is not either not informed the petitioner or nor he is unable to in a position. Well, he's so
Partho Sarkar.
Mr. Partho Sarkar. Well, in that, my lord, in the judgment which is under challenge, my lord, Mr. Partho Sarkar.
Yes.
Well,
Now, where is the application? Application will go there.
my lord, when he approached, he come before contact with me, my lord, within a week I have filed this memorandum of appeal. My lord, for such, my lord, 231 days delay is there. Well, I have stated in details when in paragraph.
Stated. Where have you?
My lord, kindly, for,
What was the main writ petition about?
this is a case for, my lord, consideration for appointment on compassionate ground. What happened in 2015, my lord? Petitioner is the son of the deceased employee, dependent son of the deceased employee. What's happening? বললাম এখন রেখে দিচ্ছি, আমার কাছে ছবি একটাই। আপনি দেখুন, আপনি চলে যাবেন আজকে দিনটা জানেন, হ্যাঁ আপনি ছিলেন, আপনি তো অর্ডারটা এমপির অর্ডারটা দেখতে হবে না, তো মেমোরান্ডাম অফ অ্যাফিলিয়েট সাথে, সেটা মেমোরান্ডামের সাথে থাকে নাকি, আর মেমো সার্ভিস হবে, অর্থাৎ অর্ডারটা সার্ভিস করবেন না, আপনি দেখুন কথা বাড়িয়ে আপনি দেখেন।
ঠিক আছে, রাখুন, আপনি আবার আমি বলছি সার্ভিস করুন, ওইভাবে দেখানো হয় না অর্ডার।
He was declared medical, he retired.
Yes.
He retired on 17th April 1996 on medical reason.
With the approval of the authority.
Very good. Now, prior to that,
No.
he made a representation on
No.
6th March 1995 for appointment of his son.
May I submit, my lord?
Yes.
Page 15, my lord.
No, please
Annex-
come to the order impugned.
No,
Order
order impugned that, my lord. What, my lord, kindly.
No, we are not we are wanting the dates.
My dates is there, my lord. In 2015, first application was made, which is
2000?
not reflected in the order, perhaps. 2015,
15.
Annexure P1, page 13.
Date.
Date, my lord, 6th 3/1995, 6th March 1995.
That is prior to his medical ground retirement.
Yes,
Very good. Your right to compassionate appointment will arise
Lordship.
after you are medically unfit.
Lordship.
Na?
Then
So
my
your
lord,
first represent even court observes that you have approached 25 years after his retirement.
my lord, kindly, my humble submission, my lord, kindly sympathetically consider this matter, my lord.
After
This is
25
continuous
years.
cause of action, my lord. This is continuous cause of action.
Compassionate appointment, sir.
My lord,
It has not exercised discretion on the ground of the delay.
Lordship,
How
Lordship,
can we help you? Tell us.
Lordship. But my lord, kindly consider, till today, they have not considered my application, which is made during my service tenure. This is my condition of the health condition. Let me retire from medical ground with the approval of the authority. My lord, I have retired.
You have
On-
retired on 17th of April 1996 on medical ground. Prior to retirement, you made a represent.
Nah, my lords, my
Subsequent-
stay application in paragraph 3, my lord. Appellate authority ultimately with the approval of the retired from his service on medical ground on and from 17th April 1996 and died on paragraph 2 of my paragraph 3 of my stay application. Page
Paragraph
4,
3.
paragraph 3. Well, this is a office order is there, my lord. Paragraph 3 of stay application.
Paragraph.
This is scan 2, my lord.
Yes.
Paragraph 4 also very important, my lord. There is a office order issued by the respondent authority, my lord, which is annexure P3. I have made amendments in paragraph 4 and the annexure is, my lord, kindly consider. Office memorandum, page 15, my lord. Page 15.
Your father was working in Group D post. Group D.
Lords,
That one.
no, this is perhaps Group C category and he is discharge his duties with full dignity as Darwan, which is Group C, my lord.
That one is
No,
Group
no,
C.
no, my lord. Group D.
Lords.
So when you retired on medical ground, what was your age?
My age is at the material point of time, my lord, only 22 years.
No, 57 years, your father said.
Your
Oh.
father's age.
Huh?
In 96 when he retired, he
Yes,
was 57 years.
yes, at the age of 22 years, the petitioner hearing.
We are not asking about the petitioner. We are asking about the petitioner's father.
Lordship,
Petitioner's father
Lordship,
retired
Lordship,
on medical ground attaining the age of 57.
lordship.
So how do you come under the circular? Circular, please come to page 15.
Lordship.
Read that middle portion.
Yes. In case of Group D employee, whose normal age of superannuation is 60 years, compassionate appointment may be considered where they are retired on medical ground before attaining the age of 57 years. That
You were 56.
before,
You were 56.
বয়স তো পূর্ণ হয়ে গেছে 12/6/19
সেটা এখানে স্টেটমেন্ট দুই 5/2003/8/2018 Where are your representations of second? Second. 799. বাবা মারা যাচ্ছে মেডিকেল গ্রাউন্ডে রিটায়ার করে রাখি রিজেক্ট হয়
And now the petitioner's my lord now about 55 years. According to my lord affidavit affirmed, the petitioner is now 55 years.
because you have not considered you have kept the man waiting till 55 years.
Yes.
The nominal policy যে আমাদের একটা লামসাম of employment এটা ফোরবেন করে গেছে
wife চলে এসেছে চন্দ্রদা his wife has come
ওয়াইফ আছে
Jyotsna Das
সেটাও
wife you are Ajit Kumar Das
অশোক দাস চেনার হচ্ছে
Oh.
অশোক দাস
now your Jyotsna Das is your mother Now mother claiming that a lump sum amount.
It's the retirement benefit, my lord. So for lump sum amount regarding the retirement benefit.
Not retired.
In lieu of employment.
employment.
Come to page 19A.
Lordship,
Last two line.
Read the last
yeah,
paragraph.
yes. Thus, I am deprived the social security in that this further life with the noble application of company policy and social security by the corporation to allow a one-time lump sum consideration in lieu of employment. It is my earnest appeal to consider my case sympathetically and granting the financial consideration of rupees 15 lakh for the act of kindness of my family. I will ever remains grateful to you. Yes. Lots. Well, this is there. This is there.
করে দেবো।
Well, let the matter be considered by the authority. My lord.
What they will consider, sir.
Regarding the
Admittedly, your representation, first representation was on 6th March 1995.
Lots.
That is prior to retirement on medical ground.
Lots.
At that juncture, they had no obligation to consider because
Lots.
the person was still in service. Now, thereafter, in your stay application, you have annexed that page 16. The next representation was in 2008.
Lots.
So 96 to 2008, how much? 12 years.
Prior to that, one my lord, my
Prior to that, no further representation.
lordship, may I? Now, his father also, after his retirement, he also made the representation in 2008.
Retirement was, he retired in 2000. Retirement date was sometimes in 2020, 2000.
No,
2nd May 2008.
17th
April 1996.
No,
Paragraph
my lord.
three. Paragraph three.
Right, কবে?
Retired.
মারা গেছে কবে? December
2018.
And mother
Prior to that, my lord, kindly see page annexure P4, page 16. The deceased employee, when he is alive, she made representation.
Yes.
2nd May 2008, page 16. Then, my lord, the
পরে representation
present petitioner before your lordship on 2008.
representation.
With his biodata, my lord. So, my lord, the petitioner first application is 2008.
Exceptional circumstances.
Sorry. Let the matter be considered, my lord. First application made by
If we considered, if we pass that order, it will enhance your sufferings. Why I tell you?
lords.
Because suppose we pass a consideration order, they do not comply. Again, contempt application. Again, 10 years will go. The person will not know his fate. Today, he will come to know his fate. So he will be having an option to approach the higher forum or to accept our order. What is with the utility in keeping the matter pending? Tell us.
No. My lord,
Fate at 55 years is there.
That-
So the
my lord, what is the reason they have not considered my application till 2015?
2015 you made representation when? Tell us. You tell us when did you apply? Your first representation was 6th March 95.
Lords.
Your father retired in 96. Then 2008, your father made a representation. Even if we accept it, it contains no receipt, nothing. Next representation was when?
2008, on the same day with biodata.
Right. Now, after that, when was the next representation?
Well, that
Why-
is,
why-
this is
That
there,
by
my
the wife.
Why?
That is in 2021.
lordship.
Then your representation you made on 28th, 26th of July 20.
Lordship.
I'm in court after 25 years.
No, but my lord kindly consider, since 1995 is a continuous course of action because
The present appeal has been preferred. An order dated 10th of November. 10th of November 2021, passed in a writ petition WTA 15979 179 of 2020.
well, 6 months, within 6 months, they have should, my lord, consider my application. My lord, your lordship knows the judgment of the apex court. When the first application was made for compassionate ground, it is to be considered within 6 months from the date of application, first application. But in this, here, my lord, though I have approached this court after 22 years, but till today they have not considered. Well, the obligation is cast upon the respondent. So,
Mr. Bose, learned advocate appearing for the appellant, appearing for the writ petitioner stroke appellant, submits
well, this is my affidavit of laid by.
তার আগে লিখো। What is that?
It is an affidavit of service, though they have appeared.
Affidavit of service filed by the appellant stroke, filed by the writ petitioner stroke appellant hearing. Kept on.
Lordship's first manner condone the delay, my lord, 31 days delay.
As we have invited Mr. Bose, learned advocate appearing for the appellant to advance his arguments on merits of the matter. We condone the delay. We condone the delay in preferring the appeal. And stop. The application for condonation of delay being such and such is accordingly Can 1 of 2022 is accordingly disposed of. Stop. Mr. Bose, learned advocate, argues that the respondents have themselves not complied with their own circular dated 2nd of January 1995, in which it has inter alia been observed that the authorities would be under an obligation to consider the claim for compassionate appointment of an employee belonging to Group D, whose age of superannuation is 60 years. Stop. In the present case, the appellant you are Group C or Group D?
Here, my lord, in his application,
কি লিখলে? না, এরকম themselves not considered their own circular dated 2nd of January 1995. In which 99 stop. The said circular provides that quote unquote the benefit of a marked out part, page 15 of this application. C বলেছে writ petition. বলেছি আমি group C। না, ওটা আসছে কিনা গ্রুপ সি বলে তো 55 কি দেবে?
This circular is not applicable because my lord, this is relating to my lord pension. Kindly,
It's for compassionate appointment.
no, my lord, kindly,
When a person retires on medical ground under Rule 38 of
my
the
lord, kindly
pension,
come to my lord first paragraph, request for grant of invalid pension.
Hmm.
In accordance with the Rule 36 CS pension rules
is received.
received.
তারপর request is made for employment of son and daughter.
For employment, son and daughter on compensation ground, yes.
আচ্ছা কি লিখলে? Provides inter alia that বলে কোট আট কোটে বলছে গ্রুপ ডি লিখে ও বলছে গ্রুপ সি if you are group C employee which you said in the read code then 55 years you retired on medical ground after 55 years 1996
But in the trial court,
you said that you retired on medical ground prior to attaining 57 years.
yes, my lord, I prior to 57 or at the age of 57.
That is in respect of group D. That is in respect of group D.
Well, that one is group D.
You have said you are group C.
My lord, D.
Petitioner.
In the trial court, I have not.
Hence we are.
My lord, in the trial court,
How Darogan can be a group C?
yes. My lord, this is, well, in the trial court, Mr. Sarkar,
Yeah. Depended that
Circular
petitioner
dated 2nd
Yeah.
father was group C.
95.
Lords,
They have themselves not complied with the circular dated 2nd of January 1995. So, he argues that the petitioner's father retired on medical grounds on
17th April 1996.
17th April 1996, and as such, the authorities were under an obligation to consider a representation made prior thereto on 6th of March 1995 for grant of compassionate appointment in favor of the appellant. Stop. Such arguments as advanced, were not taken into consideration by the learned single judge. Stop. Were not taken into consideration, and the learned single judge glossed over the said issue and did not return any finding on this. In view thereof, the impugned order is not sustainable in laws. He further argues that the learned judge are in law in not exercising discretion in favor of the appellant, though he made repeated representations for grant of compassionate appointment. Stop. Mr. Pal, next par contra, Mr. Pal, learned advocate appearing for the respondent submits that prior to retirement on medical ground, the first representation was made on 6th March 1995. Thereafter, stop. Appropriate representations thereafter were not submitted by the petitioner, by the appellant. And as such, there had been no, and as such, the allegation that the respondents have denied to discharge their obligation, is unfounded. Stop. We have heard the learned advocates appearing for the respective parties and considered the materials on record. From the annexures in the stuff. Indisputably, the appellant's father retired on medical ground on 17th of April 1996 and subsequently died on 30th of December 2008. From the annexures to the stay application, in the stay application, the appellant has annexed from the annexures to the stay application. It appears that the appellant submitted the second representation, right, about 13 years after the first representation on 6th March 1995. Second representation on
Lordship.
2nd May 2008. That is about 13 years after the first representation dated 6th March. Yes, sir.
My lord, on not, this is on 2nd May 2008. The
Yes.
petitioner made an application.
Yes, that is how many years after 95? 95, 5,
Lots,
2008.
lots.
I am not
Lots.
strong in
No,
mathematics.
no. I am sorry.
Stop.
I am
The next representation appears to have been made on about. The next representation appears to have been made by the appellant's mother on about এটা কবে? 2008 করেছিল আর এটা 21 করেছিল about 13 years thereafter on 21st of January 2021. And lastly, a representation was submitted by the appellant again on 20th of July 2023. Right? 20th of July 2023, that is after the writ petition was dismissed. Stop. In the petitioners, in the representation of the appellant's mother, she has inter alia claimed that since compassionate appointment has not been granted to the appellant, the authorities may granted to the appellant, the authorities should grant one-time lump sum consideration in lieu of employment. From the above facts, it appears. Stop. There is no explanation. There is no explanation as regards the delay in towards submission of the second representation about 13 years after the first representation. Stop. The petitioner, in fact, approached the writ court about 20 years. 96 থেকে 21 কত বছর? লাইনটা কি লিখলে? হ্যাঁ। There is no explanation. Submission of the second after the first representation. Stop. Records reveal that the writ petition in fact was preferred about 25 years from the date of the first representation. Stop. In view of the above facts, the learned single judge refused to exercise discretion in favor of the appellant. Stop. We do not find any infirmity in the order impugned, and as such, no interference is called for. The appeal and the stay application being such and such are accordingly dismissed. There shall, however, be no order as to cost, urgent, satisfied. Yes, next. Hon'ble,
My lord.
good case or bad case?
Always not. Before the division bench, obviously bad case.
Lord,
Yes, who is the appellate?
Lord, I am appearing for the appellant. But
I'm
my
for
lord,
the Union of India.
Union of India, I think, my lord, nothing to say with this matter. Mr. Tapon Mukherjee, my lord,
Appear in the single.
We saw him, he was waiting here.
no, my lord, he is in court number 5, my lord. He is telling
What
that,
is the matter about? Compassionate about it?
no. This is not compassionate, but my lord, petitioners, my lord, the appellants, my lord, initially joined in the year 1999, my lord, in the post of tuberculosis laboratory supervisor and tuberculosis health visitor, my lord, under the district health and family welfare Samiti, my lord, at Murshidabad. My lord, this is controlled by National Health Mission. My lord, on that advertisement published, my lord, it was mentioned that their service will continue, my lord, till they attain the age of 62 years. And there was a provision that year-wise renewal will be there. My lord, time to time notification was granted in 2014 and 15 to notification published wherein, my lord, the age limit was extended up to 65 years. Now, my lord, what happened in 2020, my lord, the authorities took a decision whereby, my lord, our age limit was, my lord, decreased from, my lord, 65 to 60 years. And accordingly, my lord, we have been allowed to retire at the age of 60.
Yes. Yes.
My lord, accordingly, my lord, we have been, my lord, allowed to retire at the age of, my lord, 60 years, though, my lord, in the advertisement published,
It was 62
it was 62,
and
Sub-
extended till 65.
65. Now, my lord,
So
the,
when was your discontinuance? When did you attain 60 years?
my lord, we have attained 60 years, my lord, in 2022.
Oh, that is why you came
My
before the reach
my
court. So what did the reach court say?
Reach court, my lord, come to the conclusion, my lord, since it is a policy decision, and my lord,
No,
there is,
by which circular it was brought down to 60 years
my lord, that I have
in
annexed
January 2020.
20.
Did you challenge that circular?
Yes,
In
yes,
the reach petition?
yes. My lord, I have annexed it also. In the writ petition, it was annexed.
So what did the trial judge say?
Trial judge, my lord, came to the conclusion that 1 year renewal was there. And my lord, this is entirely a policy decision of the department. My lord, at page, my lord, 86, if your lordship kindly consider.
Is there any persons in other districts who have been granted 65 years?
My lord, they are continuing.
Where do we find that?
My
Have you
lord,
argued that? Did you take a ground in
my
the
lord,
reach
my lord, at that relevant time, Mr. Hon'ble Chatterjee, this is, that was argued. But my lord, that was not taken into consideration only on the basis of the report submitted by the, my lord, state. This was disposed of.
Who is appearing for the state?
My lord, Mr. Tapon Mukherjee,
Tapan Mukherjee?
my lord.
There is a busy council.
My lord, my learned junior, my lord, go before him. Today, my lord, he is busy. Somehow, my lord, he is busy, he is in code number 5.
You bring the data that others,
My lord,
the
my lord, my lord,
separate districts
my
have
lord,
been extended.
my lord, my lord, my lord.
Then you will come under
lord.
a judgment which is in your favor.
My
But I
lord.
will not tell you which is the
My
judgment.
lord, my lord. My lord, lordship, kindly give me 7 days time. আছে তো?
If you can establish the discrimination
My-
ground, then
my-
we shall
My lord, my.
not today. Yes,
My
next
lord, kindly give me 7 days time, my lord. By this time, my lord, I will.
rotation. We will come back in rotation.
My lord, my lord.
Yes.
Thank you.
191 lordship, I am appearing for the appellant lordship led by Mr. Devendra Chatterjee lordship.
Huh?
Led by Mr. Devendra Chatterjee.
Yes. Is your other side?
No, Bunty Sarkar, 191.
Academic pursuits. Mr. Banerjee, what are your academic pursuits?
After post-graduation from NLU Bangalore, while I was sitting in 2020, idle in the home, so I published few articles in AIR and all.
PhD.
No, Lordship, I'm not that way. So I published a few articles. Those were appreciated all across. Then from Dhaka University,
Oh, I see.
I received a call.
Very good.
So for a research, this.
Yes. Who is he there in this matter?
But I am for the appellant, writ petitioner. Page 150 of the stay application will annex the impugned order.
No, you tell us now what is the
Yeah. Fact of the matter is that in the year 2018, your petitioner participated in the rally conducted by the Defense Service for the post of soldier special duty. What has happened in the matter, my lord? Your petitioner, my lord, obtained NCC certificate. NCC certificate holders did not waived in the written examination. They don't have the requirement to appear in the written examination. For obtaining the NCC certificate, those candidate who has NCC certificate, those candidate got, my lord, 100 out of 100 in the written examination for the selection process. And in the physical test, my lord, your petitioner got, my lord, 100 out of 100. 200 out of 200, your petitioner, my lord, full marks obtained. In spite of that, after publication of the merit list, my lord, your petitioner name is not appearing in the merit list. Petitioner challenged the matter before the, my lord, learned tribunal. There is a Central Administrative Tribunal of the Chennai branch. Because, my lord, the rally conducted in the state of by the Hyderabad division for all over state in the all over India.
petition was
Maintainable, because, my lord, the petition is maintainable here.
No, we are not saying that. We are asking that writ petition was decided upon exchange of affidavits.
Exchange of affidavit.
So there is no scope for any interim order.
Interim order, what has happened, my lord? 2018 selection.
Paper would be considered.
2018 selection process.
Eh.
I secured 200 out of 200 marks. That is my urgency, because, my lord, since
Did
29.
you get any interim order in the pending writ petition?
No.
That any post to
No. Only direction for affidavit after exchange of affidavit. Hearing, my lord, writ petition is dismissed.
So have you annexed the opposition?
Yes. I have annexed.
My lord.
No further document is required. No further.
The present appeal has been preferred challenging an order dated. Challenging the judgment dated 17th of August 2022 passed in a writ petition being WPA number 14652 of 2021. Upon hearing the learned advocates appearing for the respective parties and considering the materials on record, we do not find any reason towards issuance of any interim order. Stop in view thereof, no order is in view. And the application for stay is being canned such and such is accordingly disposed of. Stop. We have been informed that the writ petition was decided upon affidavits.
Yes, ma'am.
And the same have already been annexed.
Yes, ma'am.
And the same are already on record in the present appeal. In view thereof, list the appeal for final hearing.
Yes, ma'am.
List the appeal for final hearing in the combined monthly list of October 2023. Yes.
Deeply obliged, my lord.
In the month
October.
of September 20.
September, my lord. Waiting in September.
Yes.
Obliged, my lord. Grateful. হ্যাঁ দিয়ে দিচ্ছি
I'm opposing this. I appear for the appellant in this matter. Lord, there is an application for connotation of delay. There has been a delay of 84 days. Lord,
What is the main writ petition about?
the issue is the petitioner claims house rent allowance for 6 months on being transferred from
What happened to your matter that 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 instruments central government was not giving any benefit?
which matter I
That,
can't.
did they ultimately get the benefit? Some some corporation under the Union of India. Anyway, let us,
I can't recapitulate right now. Can't remember.
there is an application for condonation.
Yes,
of
my lord.
delay
There has
and
been
an
a delay of
application
84
for
days.
stay, and an
Yes, and application for stay, but my lord, the stay is really not invited, my lord, because-
necessary.
not necessary because there is
You are opposing the delay.
section 5.
Lordship, on paper, yes, but on principle, no. No, since it's a government client, Lordship, on papers.
My lord, the affidavit of service may be allowed to be filed. The affidavit of service.
Ashok, Mr. All the affidavits were exchanged.
Yes, yes.
That is on record.
Yes, everything on record, my lord, like the previous order, your lordship has been passed.
You are for all the respondents, Mr. Banerjee.
Yes, Lordship, yes.
Upon hearing Mr. Dottur, learned advocate appearing for the applicant, upon hearing the learned advocates appearing for the respective parties and considering the materials on record, we are satisfied with the explanation given towards the detail referring the present evidence. Stop. The present appeal and accordingly the delay is condoned. Stop. The application for condonation of delay being can 1 of 2020 is disposed. Stop. Stop. We do not find any. Not find that there is any scope towards issuance of any interim order, and as such, interim orders. And as such, and
Any
and the and the and the application for stay in such and such is accordingly disposed of. We have been informed that the affidavits that the meetings were exchanged by the parties in
And all are part of this record.
and
All are here.
same are already on record. So in view thereof, this the matter for final hearing in the combined monthly list of September 20.
The formalities may be dispensed with because there are some formalities, my lord. Lordship, yes, that is required. That is required.
Already we have given that are on record. And as such, all the, and as such, all formalities are, and as such, the formalities are dispensed with. As such, the formalities are dispensed with. Establishes the appeal for final.
paper book, informal paper book, he will file. Lordship, instead of keeping it in the monthly list of September, if your lordship kindly fix a date in September, because it might call between some period where I will.
That we cannot say, Mr. And we are disposing of matters, we will reach, don't worry. Yes, next.
Lordship, grateful one.
Or in the monthly, or in the monthly list of October, lordship, can it be on the monthly list of October?
September. We usually do not dispose of matter in advance in absence of the advocates. So if you are in real problem, please inform us. We will.
I am informing him that 11th to 18th, I need a.
Yes, next.
Lordship, great.
My lord, in this matter, sorry. I beg to appear for the appellant Satyajit Ray Film and Television Institute, my lord.
What are the applications?
My lord, the application is for, there are applications for stay, my lord, because, my lord, I was, the
There is also an
respondent,
application
my
for
lord,
condonation of
he was
fees.
dismissed from service, my lord. And yes, my lord, as per the, and that has been, that order has been set aside by the honorable court below, by the honorable single bench, my lord. And contempt has also been filed by them, my lord, and the matter is returnable on 8th, my lord. Now, my lord, my entire 8th of September, my lord.
My lord, I have 3 points on maintainability, my lord, which I'm very.
And my lord,
How many days? Delay of how many days?
12 days.
12 days, my lord.
Paragraph 4 is the only explanation.
My lord, it was dismissal, no?
No, compulsory.
Compulsory.
My lord, apologies. This, in this matter, there are two matters, my lord. In this matter, my lord, it was punishment was of compulsory retirements from service, my lord, and that has been endorsed by the honorable single bench, my lord, and de novo proceedings were also directed to be conducted, my lord, and that apart, my lord, all the dues were required to be cleared, my lord, if any. And now, my lord, with all humility, I submit, my lord, it was absolutely, my lord, this order of the honorable single bench, my lord, was absolutely on the point, my lord, that the chairman in the two writ petitions, my lord. First, they challenged the inquiry report, my lord. That is why the first writ petition was filed.
Responded.
I was the respondent in the original writ petition.
Why two writ petitions were filed?
I am coming to that, my lord. In both the matters, my lord,
May I assist, my lord?
there are two persons, my lord. In this writ petition, my lord, first the inquiry report was placed under challenge before the honorable single bench, and during pendency of that writ petition, my lord, the order of punishment was imposed, and that is why, my lord, the next writ petition was filed, my lord, challenging the order of punishment, my lord, my lord.
So the first writ petition is challenging the
Inquiry report, my lord.
Challenging final order in the disciplinary.
My lord.
Now the courts, what did the trial judge say?
The trial judge, my lord, set aside both the directed that de novo proceedings inquiry be conducted, my lord, and the order of compulsory retirement, my lord, was also set aside, my lord, and the dues, if any, were required to be placed.
Final order was compulsory retirement.
Compulsory retirement.
That was not interfered with.
That was not interfered with, my lord.
Then what is the necessity of sending back for fresh inquiry? Compulsory must have been set.
My lord,
That
may
was
I-
set aside. That was set
May I
aside.
assist? My lord, in the first writ petition, the subject matter of challenge, my lord, was the order of suspension, the, my lord, charge sheet, and, my lord, the report or recommendation of the internal complaints committee, which acted as the inquiry officer in terms of rule 14(2) of the, my lord, CCS rules. Now, my lord, during the pendency of that writ petition, my lord, the order of punishment was issued. It was challenged in a separate writ petition. That was the second writ petition. Now, my lord, both the report filed by the inquiry officer or the inquiry committee, the ICC, was set aside, as well as the order of punishment was also set aside. Now, my lord, challenging that order, that was done by a common order and judgment.
You were directed to be reinstated.
Yes, yes.
You are in service, no?
No, they have not yet complied with the order. That is why, my lord, I have filed a contempt application.
What was the direction in
Yes.
paragraph?
Suspension.
Yes. My lord, internal page 5, my lord, your lordship will find internal page 5 of the common order and judgment. Second paragraph, the order of punishment was set aside. My lord, it was set aside on the ground that it was issued by the governing council, which was my appellate authority. So there was a loss of forum. And so far as the report of ICC is concerned, my lord, it was set aside. Your lordship will find that at internal page 6 of the order.
Please read now. Please read
Yes,
subsequently.
yes. My lord, internal page 4, my lord. The last paragraph, my lord. Since it has been provided under Rule 6 of the said bylaws that the member of teaching faculty of
You read from subsequently and onward,
Question comes.
from the paragraph starting with subsequent.
subsequently, my lord, the paragraph, my lord, preceding that, my lord, the order of punishment was set aside.
That's right, yes.
Yes, subsequently, the question comes whether the proceeding initiated against the petitioner by constituting ICC and its subsequent finding as contained in the report dated 28th April 2016 would be permitted to be retained on record or not. This court has considered the deliberation made by the authorities in the meeting of the Governing Council dated 10th June 2016. Learned advocate representing the SRFTI has also not disputed the contents of the resolution of such meeting dated 10th June 2016, wherein it has been apprised by the chairman to the members of the Governing Council that there is requirement of de novo inquiry based on legal opinion obtained from the experts, since it was found that the report of Internal Complaints Committee was defective. Now, on the basis of this finding, my lord, the next paragraph,
On 10th June 2016 resolution, you were that punishment order was issued on 16 June 2016. On
yes,
the basis of 10 June.
10th June, yes.
I see. Then why did the council pass the improved order of compulsory retirement?
That is beyond my
But
understanding.
The chairman has himself observed in your favor that there should be de novo trial. Then why the punishment order was passed?
Well, that is
Because you know the resolution.
yes, that is annexed to my writ petition, my lord.
Because as a appeal, certainly.
My lord, even the note of dissent of the director of the institute of
Still in service. There is an order of suspension. It is revived for it. Suspension.
So the ultimate direction was compulsory retirement order set aside,
That's right.
internal complaints committee report set aside. And it was granted
de novo.
de novo proceed and to continue with
Yes.
suspension or to take any.
My lord, they ought to have reinstated me in service. Unless I am reinstated, they cannot, my lord, inquire afresh against me. My lord, that they have not complied with, that part.
No, you are under suspension.
My lord, an order of suspension can only be issued against an employee who is on the roll of the employer.
That is the court observed.
Yes,
Court
but
said that you are stealing.
they have, yes, but that they have not implemented. That is why,
They will implement.
my lord,
You
they,
are already in service.
my lord, they must at least pay me the subsistence allowance.
That-
Nothing has been paid.
To that
I have not been treated on the roll of the employer.
matter, why you are not paying subsistence allowance? What is the amount subsistence allowance? Tell us.
My lord, that I have to take instructions, my lord.
My lord, if the subsistence allowance is not being paid, that has to be paid, my lord. I'm not on the.
Pay the subsistence allowance, we take up the appeal for final hearing. So in contempt, what he will be doing is he will pray for subsistence allowance there also.
My lord,
He cannot be, what he is submitting is that you reinstate me first.
Yes.
The read court had already reinstated it. Read court has observed that you are stealing service.
yes, my lord.
So read the paragraph with us, paragraph page 6. And who are you appearing for?
My
Silent.
lord, I am for the, my lord, my lord, I am for the added respondent in the writ petition. My lord, we were the complainant on the basis of whom the, my lord, the inquiry proceeding was initiated.
But here they have not been implemented.
complaint against you.
But the
Of
complaints are,
Sexual
well,
harassment, my lord.
no,
Sexual
my lord,
harassment.
it's not the highest form of sexual harassment, highest form inside within the
My lord,
campus.
whether highest or lowest,
My lord, if
That is-
I
that
would
is-
stall
that
you
is-
speak
that
and
is on
submit, my
record.
lord.
Naturally speak against you.
yes.
Obviously.
But my lord, I have some points, my lord, preliminary points, my lord. Maintainability, my lord. Lordship may kindly allows me to canvass those points before your lordship.
The only point is, my lord, the ICC report has been, my lord, dealt with by the honorable single bench, my lord. They ought to have been filed a statutory appeal. My lord, good, bad, indifferent, and ICC recommendation.
That I can instantaneously
can-
respond, my lord.
Solve the
My
problem.
lord.
Yes.
Kindly come to the penultimate paragraph of internal page 6. Please read. Your-
So, my lord,
Since the petitioner
is still in service.
and there is an order of suspension subsisting against the petitioner, and after disposal of these writ two petitions, if the concerned authority decides to keep suspension of the petitioner alive, then the authorities are
Yes.
directed to pay
Yes, so that there must be a conscious decision to keep the suspension alive. That decision has also not been taken. Nothing has been done.
Suspension appellation.
When was that compulsory retirement order passed?
16th
Yes,
June.
16th June, my lord, 2016.
So from 2016 and your order of suspension was, when was the proceeding order of suspension?
Yes, 16th of December 2015.
16th of December 2015. Now, what will be their argument is, they will say that we have preferred appeal against the compulsory retirement order.
My lord.
So there is no requirement of taking any decision whether subsistence allowance we will keep you under subsistence allowance. Your employer-employee relationship has ceased due to the compulsory retirement order.
Yes.
So if the compulsory retirement order is challenged before us, so if we say that the compulsory retirement is bad, then question of granting subsistence allowance will not arise.
My lord, that is, my lord, that is where, my lord, I am seeking to join, my lord, issue. My lord, that is my first preliminary point. It was decided by a common order of judgment, my lord, while deciding two writ petitions analogously. They have preferred a single, my lord, intra-court appeal. In my humble submission, it is not permissible in view of proviso to Order 41, Rule 1.
My lord, it was passed in a single order, my lord.
Doesn't matter.
It was passed in a single order. It
And
was passed, my lord.
applicability of Order 41, Rule 1, my lord, apropos a writ proceeding, my lord. It has. Yes, a second point is, my lord, if your lordship kindly looks into the stay application, not a single ground. Stay, as I have learned from your lordship, is not a matter of right. It must be based on some grounds, my lord, inviting the appellate court to interfere into the order of the single judge. My lord, this is prohibited.
Stay application. Stay application.
Doctor, please take an instruction. Today you have challenged the compulsory retirement order
My lord,
and that has to be decided.
my lord.
Now admittedly, he was continuing in suspension till you pass the order of compulsory. retirement.
Absolutely, my lord.
He was continuing in suspension. Did you?
If possibly, my lord, subject, yes, my lord, I have to take instruction. But I inquired from them, my lord, till during that period, possibly he has got the suspension, subsistence allowance, my lord. Till the order of compulsory retirement was passed.
Yes, God.
Kindly bear with me for a minute. I will take instruction over phone, my lord, if your lordship kindly allows me. ওই সময়টা তো পেয়েছিল। He is also, my learned friend is
And-
also admitting that he has got the subsistence allowance during that period.
In the event, my lord, your lordships, my lord, entertain this appeal. My lord, where not a single document has been annexed, there is not a solitary whisper on the grounds on the basis of which the respondents are seeking intervention of your lordships, my lord. This, my lord, in my humble submission will create a precedent, my lord. This
My
is
lord, all these
prohibited, my
technical
lord.
issues, my lord, we have preferred the in the we will be, if your lordship directs us, my lord, I will be submitting the paper, prepare the paper book also, my lord, and in the writ petition they have already annexed all the papers, and we are on a bylaw, my lord, on a service bylaw, my lord. What I am on, my lord, if your lordship kindly appreciates, my learned friend so long was.
Your challenge to the compulsory retirement, you satisfy us then. Then why should we stay the matter?
Yes, my lord, I'm placing it before your lordship, my lord. The main ground, my lord, on which the writ petition was filed, my lord, was that.
Certain, you have the writ petition copies. How can you show us the documents?
Yes.
We have nothing here.
And that is what specifically has been, my lord, contended at Rule 4 of Chapter 4 of the Appellate Side Rules and the law laid down in Bharat Singh's judgment by the Honorable Supreme Court. It cannot be entertained.
Law laid down.
Yes.
We can call for the writ petition.
No, your lordship.
Appellate court, we can call for the.
My lord, that.
Yes, my lord, this was passed, my lord, apropos a writ proceeding, wherein it has been, my lord, specifically held that, my lord, if a point of law is required to be if a point of law, my lord, is required to be substantiated by facts, it must be pleaded, and evidence in support of such pleading must be annexed to the writ petition. Not a single document. And if your lordship kindly takes the trouble to look into the, my lord, stay application, there is no ground at all.
All the documents, my lord, that were annexed with the writ petition, opposition and reply, my lord.
What you have filed and
My-
that annex those.
My lord, that I apologize, my lord. My lord, if your lordship
paragraph.
kindly calls for the record, my lord, kindly.
For the level contempt will not be taken up. Contempt is a.
Yes. And what are the grounds? I'm surprised, my lord. Only one paragraph. That to avoid legal complication and multiplicity of proceeding.
Here, are we not having the jurisdiction to see the records?
Yes, obviously. Obviously, but there must be what I am most humbly trying to impress upon your lordship, my lord.
You have the petition?
Yes, I have. My lord, they must make out some grounds.
Because unless we see the internal complaints committee report, the compulsory retirement order reports, if are not reduced, why should we grant to the state?
My lord,
My lord,
if
the
your
onus was
lordship,
upon them.
Wait, sir.
if your lordship kindly appreciates, my lord, the de novo, as regards the de novo My lord,
Contempt, that is the first date.
No, it is returnable on it. Yes, first date notice was directed to be issued. Notice was directed to be issued on the first date. It is returnable on 8th of September.
my lord, if your lordship kindly hears me for a minute, my lord.
What we will hear, madam, you have not enclosed the.
My lord, I apologize for that. But my lord, if I have absolutely filed this, my lord, appeal, my lord, on the basis of the observations in the writ petition, my lord, in the order passed in the writ petition, my lord. The honorable single judge, my lord, has accepted that we have said that the service rules, my lord, that is that is not binding on us, that he has to be ascertained by the order of penalty, my lord, has to be issued by the chairman, by the governing council or the chairman.
We are desirous of hearing. But what records you will place, madam, that this is the resolution, this is the complaint committee resolution? How we cannot hear it in the air, na?
My lord.
To come with the documents.
My lord, may I humbly submit only one thing, my lord? What is admitted, my lord, that there is an ICC report. It is admitted. My lord, what is also admitted that on the basis of the report, my lord, an order of punishment was passed. My lord, these two facts are admitted. My lord, my humble submission before your lordship is that if an order of punishment has been passed on the basis of an ICC report, my lord, without assailing that ICC report in an appeal, statutory appeal under section 18 of the Act of 2013, my lord, the order of punishment cannot be assailed, my lord.
My learned
Before-
senior friend
before a
has not
report,
referred any appeal, my lord. And he is not a party in the appeal. He doesn't have any audience.
আমরা তো edit respondent, রিটে। হ্যাঁ, সেটা এখনো আমাদের
You file, you bring all the materials on record. We are fixing the main appeal for here.
My lord.
We are fixing a date. We will hear no interim application, we will hear out here.
My lord, on 8th it is returnable, my lord, the contempt application. The contempt application is
For an adjournment. We will.
Or any day prior to that,
Prior to that.
subject to convenience of your
My lord, if
lordship.
your lordship directs me to file a paper book, my lord, annexing all the documents, may I file a formal paper book, my lord?
Yes. We will file, you file, when will you file, tell us?
In 7 days, my lord, not more than that. Informal paper book.
But we will keep the stay application alive. We will, till that time, we will keep the stay application alive.
My lord, as your lordship desires, my lord.
Paper.
But if on the 8th, my lord, I am apprehensive if the rule is issued or something like that is done, my lord.
Take an adjournment on that.
I shall intimate, I shall, definitely.
My lord, if your lordship passes an order to that effect, my lord, only for a day.
You file a supplementary affidavit, bringing all the materials on record. Then let us dispose of your stay application. And if at the time of disposal of the stay application, we can take up the main appeal.
Main appeal.
As your lordship directs, my lord.
In your supplementary,
My lord.
file both your Writ petition affidavits were exchanged.
My
One
lord,
of the writ petition.
Then bring that on record, otherwise we are not granting it.
my lord,
Unless you show us along with the complaint committee report.
my lord, I will.
Ashok. Delay of how many days?
12 days, my lord.
Upon hearing the learned advocates appearing for the respective parties and considering the materials on record, we are satisfied with the explanation given towards the delay in referring the appeal. Stop. Such delay is accordingly condoned and the
Deeply obliged, my
application and such is disposed of. Stop. Is Dr. Learned advocate appearing for the appellant prays for leave to file a supplementary affidavit. Stop. Such prayer is considered and allowed. Let such supplementary affidavit be filed within 2 weeks from date with copies to the learned advocates appearing for the respective respondents.
My lord.
Stop. Please the matter. The appeal as for orders in the daily supplementary list of this book on
Can one.
as for orders in the
From the
daily
report,
supplementary list
you
of
will
this
not get it
On,
from the report.
কত বললে 15 on 50.
my lord, on
On-
15th, I have some difficulty. On 15th September, I may have to travel, my lord. Prior to that, my lord,
On 18th. On 18th.
my lord.
On 18th.
ডেটটা লিখে রাখবেন।
13 তারিখ চোদ্দ তারিখ হচ্ছে on 22nd on 22nd.
My lord, only one indulgence, my lord.
Mr. Ganguly learned advocate appearing for the respondent number
Writ petitioners.
for the writ petitioner stroke respondent.
Sir, there is only one respondent in the appeal.
My lord, I have.
He doesn't have any audience, my lord. That is what I
Kindly
have tried
seize the
to.
order. My lord, kindly seize the impugned order, my lord. We were the.
You are a party to
Yes,
the
my lord,
Yes.
we have been added in the writ petitioners parties by them, by the writ petitioners, on the basis of an application for addition of party, man.
Yes,
My
but
lord,
they have
kindly
not
seize the
preferred any
impugned order, my
independent appeal,
My lord, I have preferred an independent appeal, my lord, only
not served on me.
the memorandum, my lord,
has not been served, my lord. The problem is, my lord, the
Here he has added appellants are such and such, only one respondent.
yes.
You have not been implemented.
My lord, kindly sees the impugned order. My lord, we have been implemented in the writ petition by the writ petitioner,
Both the writ petition.
both the writ petition, on the basis of an application for addition of party.
So your appeal is defective.
Your defective.
Yes, my lord. I ought to have added my lord.
Department বলে দিল inform. Department inform বলছে।
Only delay of it. Actually,
No, Mr. Banerjee,
My lord.
your name does not feature in the
Impugned
list-
order.
in the array of parties.
My lord, in the impugned order, it features, my lord, kindly sees.
Yes, he was added.
When it was allowed.
My lord, I had filed an application for addition of party in the writ
It's
petition.
allowed.
That was allowed, my lord,
And
that
who was
application.
given the leave to correct the cost item.
My lord, the writ petitioners,
That is why he has not taken.
the writ petitioners.
You ordered them.
Where is the allowed, it is, his application was allowed.
His application was allowed, my lord, as it appears from the order impugned before your lordship. And I'm being candid to your lordship, at that point of time, I was not there, my lord.
No, he was not there, my lord. It
Yes.
was being Mr. Ornav Mukherjee, as I remember, my lord, he was the
the
applicant.
petitioner was given liberty to add him,
Yes, my lord.
Must have.
yeah, to correct the cost item.
There ought to have
That
been
has,
such a direction.
that has not been corrected, my lord. That is, I also ought to have seen it, my lord. I apologize. But it was not there in the cause title, that is why.
Section 5 টাও
Cause title টা amend করেন।
all you have only added him.
My lord, because it was not featuring in the impugned order, my lord.
No, impugned order.
No, I'm not on that cause title of that. I apologize. I stand
Where
corrected.
is it is mentioned your application was allowed?
My lord, that was an earlier order, my lord. That was an earlier order.
Mr. Ganguly, you,
I will try to.
But I will produce the order on the next statement.
that fact is true.
Yes, my lord.
Absolutely,
Yes.
my lord.
My lord, kindly sees the impugned order, my lord. It has been
Yes.
mentioned as private respondent
Page 4 of the order.
in the impugned order itself.
না, তার উপরে একটা প্যারাগ্রাফ দিয়ে দাও। Is Dotto learned advocate appearing for the appellant? Dotto learned advocate appearing for the appellant submits that inadvertently. What is your name and address?
My lord, I will mention that file.
Added respondent have not been made party.
Application টা
আচ্ছা, ঠিক আছে। Inadvertently, the name of the, inadvertently,
What application?
the added respondent in both
My
the
lord,
appeals.
my lord, it is appearing that, my lord, they have added me as a respondent in the writ petition. My lord, and the, yes, and the, my lord, the amended writ petition, copy of the amended writ petition was, my lord, sub.
But in the certified cost title of the certified copy,
It is not there.
it is not there.
My
Why
lord.
to added respondents? There are two persons.
Two persons, two complainants. In both the writ petitions, two sets of complaints.
বলে, The added respondents in both the both the appeals
Are rated.
have not been included. And she prays for have not been in view thereof. In view thereof. The added respondents are directed to be added as party respondents in the present appeals. Stop. Leave is granted to, you are the record on record.
My lord.
Leave is granted to Ms. Dotto to make necessary corrections in the memorandum of appeals, in the memorandum of appeal and the stay application, applications and the application.
My lord. My lord.
Application for condonation of delay. You add them in all the cost items. তারপরে লেখো upon considering delay condon, the matter for as for.
Only one indulgence I am seeking, your lordship may kindly grants me liberty to reiterate my preliminary points on the returnable side.
We have not decided because
Very-
otherwise we would have said that this technicality is not required. We have decided nothing. So we are recording, Mr. Ganguly, that you pray for an adjournment in the contempt.
Deeply
On
obliged, my
each.
lord.
If that is the desire of your lordship can do that. Otherwise, I can undertake, I will do it.
Or not to.
I will
record.
do it, my lord. There is no.
My lord, if your lordship kindly passes that order, my lord.
The learned advocate says that he will do it. I don't think.
My lord.
I shall
Any
definitely
honorable-
do it, my lord.
any learned single judge that we have fixed it on
Yes,
that
yes,
date.
definitely. That is my
Any
duty, my
other
lord.
date for here. Any other date.
That is my duty. Yes.
Yes, Mr.
Deeply obliged.
Yes, ma'am, sorry.
Mr.
Yes.
Rao. Mr. Rao,
Raut
you
is-
are-
Mr. Raut is here.
oh, extension.
No,
office.
no extension, my lord. On the earlier occasion, my lord, your lordship has been pleased to, my lord, fix the hearing of the appeal. That's why your lordship did not. No, I am not facing any contempt application. Your lordship, on the earlier occasion, your lordship was pleased to, you know, direct the parties since the paper book have already been ready. But your lordship has been pleased to fix the matter for hearing of the appeal itself.
I can.
But today,
No.
today,
আজকে
and Lord, on the earlier occasion also, they have prayed for, Lord, extension of the interim order. I submitted that the interim order was not there. A first interim order has to be passed by your lordship. Then, my lord, your lordship has been fixed the matter to fix the matter today for hearing. And Lord, all the paper books are ready and complete. Lord, this is the matter of, Lord, dismissal.
কবে ফাইল করেছো ডেট ট্র্যাকিং হুম 13th
So it expired in June.
30th of June, Lord, was the last date when it
When
expired.
did you file the application?
I am told, Lord, it was filed post that date because, Lord, it was mentioned, Lord, in between on 28th of June 2023, matter was directed to appear in the list. It did not appear. Then, Lord, before the learned judge, Lord, on 5th of July, the matter was again mentioned. The Lordships will get this from paragraph 5 and 6. When, Lord, these two mentionings did not mature in having the matter listed, then, Lord, this application was taken out on 13th of July. But Lord, I can assure your Lordships, Lord, kindly see the order of 18th of January 2023. Upon contested hearing, the interim order was granted. And Lord, then we were asked to file the paper book. We have filed the paper book within time. There is no default so far as we are concerned. 18 January, kindly, my Lord, have a look. Your Lordships will find that upon contested hearing, this interim order was granted.
Paper books have already.
Yes, yes. We have complied with every direction of this honorable court. And Lord, in earlier occasion, there were two earlier occasions when the order was extended. First is, Lord, on 1st of March,
No, no,
Your-
when was the order for preparing paper books?
18th January.
Page 9.
January.
Since January, my lord, they have taken the.
Uh-huh.
Since January, my lord, they are taking the, my lord.
What can I do,
extension of
my lord,
the
if the
order,
mat-
my lord. That's why, my lord, I am praying, my lord. If it is not possible today,
Lord, kindly see the order of 18th of January.
What did the main writ petition contempt file?
my lord, I submitted on the earlier occasion. There was a contempt file. I, my lord, undertaken on the earlier occasion that I will not proceed the contempt. Even also, my lord, the last date was there. I paid for adjournment because of pendency of the matter, and your lordship has been pleased to fix the matter today. Again, my lord, the contempt will appear. I will pay for adjournment.
Lord,
Only, my lord,
the
my
contested
entire-
hearing, Lord, we have got the order of stay. There is no reason, Lord, today, there is no change of circumstances on which, Lord, my,
Or you were not there on the last occasion. I
Yeah.
didn't remember. He appeared.
yes.
So I said, an adjournment was sought for. So then I asked him, is there any contempt? He said that yes. So I told him, we told him that don't proceed with the contempt.
No, that is fine. That is fine. But Lord, I got an order of stay, Lord, on contested hearing. It's not that I'm prepared, Lord, to place my appeal also. I'm ready. But Lord, why I don't find any reason to resist, Lord, extension of interim order from January 23rd, 2023. This has been extended twice before. And those both the occasions, Lord, court has extended the time fixing the date of hearing of the
After
appeal.
filing the
The
paper
court
books.
could not take up the appeal.
After filing the paper books, my lord. Lord, my endeavor, my lord, only
What can I do, Lord? If the court
Mr. Kumar is there, my lord. I cannot open my mouth.
no,
More than that.
you can always
Mr. Kumar is there, my lord.
he can always speak for his client.
My endeavor only, my lord, to hear the appeal,
Yes,
nothing else.
I don't disagree there. I am saying that
Then,
fix a
kindly-
date.
Fix any day, any time. Kindly fix any time. my lord.
Fix a date,
Then
extend the
any-
interim order. That is
So far-
precisely
Lord,
what I
so
said.
far the interim order is concerned, it has already been expired. I, Lord, kindly record my submission that I will not proceed any contempt till the appeal is heard.
Extend it for a limited period.
Very-
This cannot be, not extended. Look, kindly see the prayer of the application.
State and
But you have, your lordship has to pass the interim order of praise.
If I record your undertaking and we pass interim order, that same will be. effective to say.
Lord, if your lordship do not
Your
records my,
satisfaction-
if your lordship do not records my undertaking, there will not questions of not extending the interim order, that will not like it.
Yes, effect are same.
That is why my brother says, let us extend.
Lord, kindly fix the matter, not any day and time, Lord, as early as possible, Lord.
পরে আর করে দেবো। Mr. called and advocate appearing for the appellant submits that initially an interim order was passed in the appeal
Lord, 18th of January 2023.
on 18th of January 2023. Stop. The said interim order was also extended
On 1st March 23 and 16th May 23
on 1st March 2020
and 16th May 23.
of May 2023 till the month, till the end of June,
In
till
the
the end of June 2023 or until further order, whichever is ordered. Mr. Court further submits that prior to expiry of the interim order, the matter was mentioned. The matter was mentioned. Where you have state
Lord,
paragraph?
paragraph 5 on 28th of June 2023.
The matter was mentioned on 28th of June 2023.
Lord, the matter did not appear.
20th of June 2023, but the matter did not appear prior to expiry of the interim. Prior to stop.
Lord, that is not correct. Lord, sorry to interrupt, Lord, prior to expiry of the interim order, Lord, their matter was appeared before, Lord, their lordship, Lord, having determination. Matter was appeared.
But it was not
Matter appeared, taken up. It can be said at best taken up. Did not taken up.
I'm sorry, Lord. I'm sorry.
ছিল।
mentioned on 28 June 2023, but the matter would not be heard. But the
Yes.
matter would not be heard.
Yes, yes.
Stop. In view thereof, the present application for extension of interim order has been. Stop. Mr. Rao, learned advocate appearing for the respondent. Respondent. Opposes the Mr. Orr's prayer for reinstatement and extension of the. We have hardly learned advocate for 650, so, have been informed that the paper books have already been.
Yes.
And the appeal is ready for.
Okay,
hearing.
yes.
Upon hearing learned advocates appearing for this part, having heard learned advocates appearing and considering the materials on record, we do not find any change in circumstances, and as such, the interim order initially passed on 18th of January 2023 is reinstated and extended till the end of September. 16th of October 2020 is the appeal for final hearing in the daily supplementary list of this court on
জিজ্ঞেস করছে
25th. The application is being such and such is everything is disclosed.
অক্টোবর
ও সেপ্টেম্বরের লাস্টের দিকে দেখুন
সেপ্টেম্বরে লাস্টের দিকে
on 25th September. Please the approval.
But any prayer can be renewed from my side.
What?
For your lordship fixing the matter on 25th September.
We have extended till 5th.
No. So that the exercise comes from submitting anything. Only some precedent should be given.
In the supplementary.
Supplementary 28th of 5th September, if it is not, we want some, but no, it will not take much time, Lord. It will not take much time. Mr. Kaur will take the time. I will not take the time. I will not take the time. And if it is possible, my lord, kindly fix any time, my lord.
But it is better to have it on a day where your lordship's lord will be able to take it up.
Yes, 15th September, any time is not. Any time is.
Time specify করতে হবে তাই কি?
I'm grateful, my lord. I'm grateful. I'm very much grateful. এটা ভালো বলেছে ডেট ফিক্স হয়েছে তো
It's an identical matter, my lord.
It's an identical matter with delays of 25 days, my lord. And
Yes, the previous matter, 193. The sexual, two writ petitioner,
two
two writ
individuals.
petitioners, they had individually, they had filed two writ petitions each.
Same.
Almost same. The
Almost
only
same.
difference is, my lord, that the writ petitioner in this case had superannuated during the pendency of the proceeding. So liberty was given to him to make a representation seeking the terminal dues, and the institute was given a direction to decide on that representation. That is the only difference.
They are also compulsory return.
Yes. Same punishment.
Dismissal would have-
No, compulsory.
That's why.
My lord, in this matter also, I may be granted liberty to correct the cause title.
Yes.
Deeply obliged, my lord.
But don't fail to file the supplementary.
I will, my lord.
Then the entire thing.
No, my lord, I will file, my lord. Deeply obliged, my lord. Deeply obliged.
I am for the appeal in this matter. Railway is the appellant before your lordships. I am challenging the order passed by the learned, my lord, single bench, by which the reinstatement along with back wages has been allowed. The matter is very short. The person who has applied for employment, he, at the time of filling of, my lord, the form, has suppressed the criminal case which was pending at the relevant point of time against him. Now subsequently, my lord, he was selected, and after completion, my lord, there is a, my lord, procedure to police verification. After selection, there is a police verification. And the police verification, it was found that the relevant point of time, he, my lord, having the criminal case, but still he has suppressed that criminal case. That is the only point, and for that reasons we have terminated his, my lord, service, and subsequently he has challenged that order, my lord, and that order has been passed, by which, my lord, the reinstatement along with, my lord, the back wages has been allowed. This is
Contempt file?
My lord,
Any contempt application file?
no, my lord, contempt application has not yet been filed. Because the stay application is pending for a long time. That is why I did not file contempt. But you will also kindly go through the judgment. The trial court has considered each and every point. After considering the judgment of the apex court, in several judgment of apex court in this point has been passed. The judgment was quoted. You will also kindly consider the judgment of the trial court impugned, page 19. The judgment was started, page 19.
The writ petition was on affidavits.
yes, my lord.
Affidavits you have not brought in?
Everything I have pointed out, my lord.
No. Affidavits are in the file.
My lord,
In the trial court, affidavit and reply was completed.
my lord, very short, my lord, if you also kindly see, my lord, page 60, my lord, page 60, my lord. My lord, this is the attestation form filled up by the, my lord, writ petitioner. Now relevant page is page 62. Have you ever been prosecuted at top, my lord? No. Have you ever been prosecuted? Have you ever been arrested? Everything, my lord, he has stated no. This is the only ground, my lord, for which we have terminated from him service, my lord.
Another. It's not of the petitioner. It's
Desired as
the-
of hearing out the main appeal. So
My lord,
he are desired as of hearing out the main appeal.
but my lord, I am
Yes, yes,
opposing
my
the
lord.
stay. I am
No, no.
opposing the stay, my lord.
Hearing.
Stay we are not decided. We will hear out the stay as well as the appeal.
But
Yes, yes, my lord. We are, my lord.
We were wanting as to whether the affidavits are on record. But the affidavits are not on.
No, my lord, I should not suffer if they do not file the affidavit.
No.
Matter stay application is pending for a long time. My lord, the writ court directed that within a period of 4 weeks, I shall be reinstated in service. Order was passed in the year 20. My lord, 15 July, yes, 22. And today is, my lord, 15 July 23 has been passed. For more than 1 year, they are flouted the order of this honorable court.
No, in time we have filed the appeal.
To reinstate me.
Matter is running in the list.
Stay order. How they can, my lord, sit tight
My
on
lord,
the matter
matter-
by mayor filing the stay application?
So you did not take steps, Mr. Majumdar. You should have
Take it
filed
over.
the contempt and taken appropriate steps. You also slept over the matter.
My lord, as the appeal stay application was
Now
filed,
we are arrested.
Lordship kindly see the judgment.
Yes, we will see.
Yes, your Lordship kindly,
My lord, date is very relevant at page 62 at bottom, if you lordship kindly see.
Yes, matter.
my lord, the apex court in, my lord,
দাঁড়ান, আমাকে বলতে যে আমি নার্ভাস হয়ে যাই এমনি করলে।
now nervous হবে না তো।
দাঁড়ান, আমি বলছি এমনি করলে কি করা হবে? মানে page 62 sorry, my lord. Page 62, if you lordship kindly see. Kindly see the, my lord, date is very relevant, my lord. Kindly see at bottom of this, my lord, document, page 62.
Yes,
My lord, 2nd June 2014. And my lord, at my lord top, my lord, I have the, my lord, এটা কি yeah.
Yes, he shows that he was not, he said that he was not arrested, he was not prosecuted.
Prosecuted. My lord, so now subsequently, my lord, we have, my lord, selected him in my lord service. He is sent for provisionally selected. Thereafter, he undergone training. By this time, my lord, we sought for police verification, and police, my lord, said, my lord, he was, my lord, prosecuted, and my lord, he was, my lord, arrested, and his name was there in the, my lord, criminal case. No, my lord, if you also kindly see the order impugned, my lord, everything has been recorded, my lord.
What everything recorded? We must see the documents, na?
My lord.
Where is your police verification report?
You have to go there. Police will last night.
Only incomplete documents, they did not file the documents. Why should we pass an order of stay?
Lord. Police verification is লাগাবি রে বাবা।
Unless you place before us the.
Yes, my lord, I understand, my lord. This is my fault, my lord. Employment duties. পিভিআরটা লাগাস নি এর। লেটার আমরা বলছিলাম। টার্মিনেশন লেটারটা কই? এইখানে বল। Page, my lord, 45. Is termination letter, my lord?
Verification
My
report.
lord, it is mentioned here, my lord. If you also can listen.
Mentioning will not help now, Mr. Ghosh. You have to bring on record the document.
I understand, my lord.
How will you argue this?
Well, I understand. Well, my lord. But then, my lord, I will.
It was annexed in the petition.
my lord,
It was annexed in the petition, police verification report.
no, my lord, I annexed the termination order.
Oh,
No, in the writ petition, in the opposition, they brought.
Police verification report was not given to me. It is kept before the my lord, concerned authority. Concerned authority considered the police verification report and passed the order of termination. It was not supplied to me.
My lord, page 45, my lord.
I have
Kindly
no
see for
access.
once.
What the same?
one case, Chagda PS police station, case number 103. It was started in 2011.
Yes.
Thereafter, the offense was compounded
My lord, that is after selection, my lord.
after selection. In
Mhm.
2015, the case was ended.
My lord.
But this
But
was the
before that,
first case,
before that,
is why prosecution, my lord, the
before
component
that,
withdrew the case. This stated that
my lord, may I read, my lord, page 45?
Act.
At the time of, my lord, declaration, my lord, there was a admittedly police case.
Yes, sir, there are.
Yes, this is the only point, my lord. Now, page 45, on the ground of termination, we have, my lord, given, my lord, kindly see. In attestation of form dated 2nd June 2014 submitted by you, it was declared that you have not been prosecuted ever. Even put on receipt of the police report, it is seen that you have been prosecuted in Chagda police station case number such and such dated of 2011. And the case was ended on January 2015 while you are in training.
Your above act of not discharging pending police case in attestation form tantamounts to false declaration, hence in terms of the rule 67.2 of the RPF rules 1987, competent authority has discharged you from the enlistment for the post of constable of Eastern Railway. With immediate effect, in view of the above, you are directed to deposit all account treatments issued due course of training and to the office immediately. Subsequently, he was, my lord, discharged. But, my lord, at the time of filling up the form, he was admittedly prosecuted, my lord. And next page, page 46. Page 46, my lord, kindly see the date of the order of the my lord, trial court, lower court, my lord. 2nd January 2015.
Very good. Now, what did the court observe?
Trial court has directed reinstatement with back wages.
What are the reasoning? What is the reasoning of?
Since, my lord, he has been acquitted subsequently, so, my lord, compounded. The offense has been compounded because this was the compoundable offense and with de facto complainant, and, my lord, they compromised the issue and withdrawn the case. দাঁড়া না। ঠিক আছে।
Have you brought up the scene?
Well, I will, my lord, place one latest judgment of the Honorable Supreme Court in a self-same rule considered, and, my lord, in a RPF matter, my lord, and the Honorable Supreme Court only allowed the reinstatement without back wages, that too in a case where, my lord, the person has, my lord, acquitted. After that, he filled up the form, and, my lord, subsequently it was found that he has.
Not after seeing.
Now, after seeing, my lord, all judgment, my lord, here, my lord, considered, I will show to your lordship the another.
Here, the order has been passed on the basis of after seeing.
But, my lord, subsequently I found, my lord, this judgment considering the RPF rule, the Honorable Supreme Court has passed.
Considered that, but you have to show us how after
And-
seeing was made happy.
No, my lord,
Judgment was on the basis of after seeing.
after seeing, my lord, we have not brought, my lord.
that you have to bring. After seeing, so far as I remember, so far as we remember, the matter was sent back to the authority to consider.
No, after seeing case, my lord, Supreme Court, Apex Court held full bench judgment that what tribal nature of offence. The petitioner cannot be. Lordship kindly, my lord.
After seeing, have you brought?
Yes, yes, I have brought. Paragraph 21 onward for tribal nature. Thereafter, my lord, the again full bench judgment came of the Apex Court, Imran Khan case. And Imran Khan case considered the my lord, reinstatement of the judicial officer. He against him was the charge that he also suppressed the fact that criminal case pending. Imran Khan's case, court full bench judgment considered that no.
Imran was
Subsequent judgment, 2018. I have come, my lord, I am giving you lordship one by one. And thereafter, last judgment of Pawan Kumar case, Supreme Court, in RPN matter. And all this judgment was considered by my lord.
Do you have your opposition? Do you have your opposition?
Opposition, my lord. My lord, yes, yes, opposition is. Opposition and reply, both are there. This is the opposition filed by them.
This case, no such suppression and politics by controlling the land. Opposition has proven the case of our failure considered. আবার এমপ্লয়িকে কন্ট্রোল করো যে আমার তারপর মোহাম্মদ ইমরান এই আয়াত করে ইমরানে আমি separate.
File a supplementary affidavit bringing on record the opposition and the reply.
My lord, will do this and
The affidavit in opposition and the reply and the writ petition you have annexed.
writ petition we have annexed, my lord.
You have all annexed all the annexures.
My lord, yes, writ petition I have annexed.
So, bring on record, we finally hear out the matter.
Well, only one thing, my lord, may I place this judgment because in the
Consider the judgment, let us be apprised of the facts.
my lord, because
The procedure will be there.
well, here what happened, my lord.
What is your, you give us your citation to us.
My lord, on my lord, judgment of Pawan Kumar versus Union of India and others. I have the
Pawan Kumar
copy.
judgment I have annexed. That is in the judgment. Pawan Kumar judgment is also. Well, court has recorded, trial court has recorded Pawan Kumar judgment.
Pawan Kumar was considered. With judgment, you are saying that no, you have not placed.
Pawan Kumar judgment, my lord, Pawan Kumar size
The Pawan Kumar was considered by.
but my lord, in Pawan Kumar case is identical issue, my lord. I will, my lord, in
Only Pawan Kumar you are done.
yes.
Pawan Kumar is already there.
Well, kindly see, my lord, in the same, my lord, notification, this judgment has considered by the Honorable Supreme Court. What Honorable Supreme Court has said, my lord, if you pass, my lord, if you kindly come page 64, my lord, for a moment. Page 64 of, my lord, stay application, my lord.
Page 60,
64 of the stay application,
page 64 of the stay.
my lord. Can I see at the top, employment notice number 1/2011. Now kindly come paragraph 19 of this judgment, my lord. Selected pursuant to this participation in reference to employment notice number same. So under the same employment notice, this judgment of the Honorable Supreme Court has passed.
But these sections,
My lord, here, my lord, my lord, in this judgment, he was acquitted honorably. But in this case, he was, my lord, the offense was compounded, though this fact is something different. Even then, the Honorable Supreme Court restricted the relief. But fact is, in this case, at the relevant point of time, the criminal case was pending. But in this case, the criminal case was ended with, my lord, honorably acquitted. Thereafter, he filled up the form. Paragraph 4 of this judgment. Kindly see. Considering the self-same notification and self-same rule.
then what did the trial court say as regards this judgment?
My lord, actually, I was not in trial court, but sorry, my lord, I must be, my lord, prepared with this point. But if you also kindly see paragraph 4, my lord.
Mr. Ghosh learned the advocate appearing for the
তোরা
appellant
বসছিস না কিছু না বলো
for leave to file a supplementary evidence.
দাঁড়া দাঁড়া আমি বসবি আমার সঙ্গে একদিন যেতে ভাবার আগে
File a supplementary evidence. Let such supplementary evidence be filed within a week from date. Within a week from date. It's the appeal and along with the application for stay for final hearing. The daily supplementary list of these two. On 13th September.
my lord. হ্যাঁ সাথে মতো পড়বো তাদের একটু বস আমার নিব সাথে বস নাম করতে
Mr. Mujumdar, take back your office.
কেন
The supplementary evidence bring the opposition reply and any document, any annexures to the writ petition if you have missed out.
my lord, including the police verification report, my lord.
Yes.
My lord,
All
my
the documents which
My
were
lord, my lord.
considered, please annex in the supplementary.
my lord, my lord.
Dispensing with the formality.
My lord, my lord, my
Take up the-
lord.
Yes, next, take back your judgment.
Date of judgment বলো তো
বলে দিচ্ছি
date of judgment বলো
ডেট অফ জাজমেন্ট হচ্ছে 2 মে 2022
হ্যাঁ
2 মে 2022
I have for the
Yes.
I am appearing for the writ petitioner.
I have for the appellant in this matter, my lord.
I am appearing for the respondent number 5.
Over this,
WDA
over this
TV.
matters controversial, I'm appearing for the respondents number 3 and 4 led by Mr. Ranjoy. Here for respondents 3 and 4 led by Mr. Ranjoy.
My lord, my lord, the subject matter of challenge in this appeal is, my lord, impugned order dated, my lord, 23rd of August 2022, which is at page, my lord, 61. That the last annexure, my lord. My lord, what happened, my lord? I'm giving a brief, my lord.
It's an interim order.
Yes.
That was an interim order, later, my lord, yes.
How you are agreed by it?
Yes.
My lord, your lordship kindly says, my lord, the petition, my lord, the respondent, private respondent, my lord, has filed writ petition against the West Bengal State Distribution Company. We were not a party to the proceeding.
Which private?
My lord, I mean, my lord, this is the members, this is member, my lord, wife, was the, my lord, has filed writ petition where they have made party to the West Bengal, my lord, the electricity company, my lord. Now, my lord, during the course of hearing, we have been implicated as a party on the wrong on the wrong submission made by the the West Bengal Distribution Company, my lord. That that Provident Fund Department will give pension and all that, Provident Fund, everything, my lord. But if your lordship kindly takes, my lord, all the annexures I will show, they have got their own gratuity death come.
Chad, how you are agreed by this order?
Agree, my lord. I have been told, my lord, I have been directed, my lord, to give the petitioners, my lord, release pensionary amount, my lord, with all interest and everything, my lord. Your lordship kindly takes, my lord, I'm just, my lord, placing the order. And my lord, what they did, 1,27,000, my lord, they have deposited with the Provident Fund Authority.
Terms of the order of the court.
They cannot.
You are appearing for whom?
WBSCDCL.
Yes, I'm coming, my lord. There. My lord, should I place, my lord, the order?
Just.
Yes, my lord. Order is required, my lord, to be placed.
You are for respondent number 5 in the appeal.
In the appeal.
Now, direction was given upon who was respondent number 5 in the reach
The
petition.
PF.
That is PF authority.
Provident Fund Authority.
PF authority.
By impediment.
PF authority, that is
Appellant
respondent
before you.
number 5 is Regional Provident Fund organ.
Yes.
Now, Regional Provident Fund has come up in appeal.
Yes, my lord.
Now,
Being agreed with that, my lord, order, my lord.
is the order?
Yes, my lord. My lord, which is the page 61, my lord. I'm just placing, my lord. My lord, on behalf of the page 61, on behalf of the Employees Provident Fund Organization in SOT EPF, a bunch of documents has been made over to court, which are written with the records. The first document is a letter dated 11th of August 2022. In the said bunch, there is also a memo dated 4th May 1985, issued by the West Bengal State Electricity Board. One of the provisions to one of the provisos to paragraph 2 of the said memo provides as follows. In case of an employee who died after the 1st April 1981, but before the issue of this order, pensionary benefits may be settled at either of the rates which will be favorable to him. The employee concerned, being the petitioner's husband, died on 19th April 1984, that is after 1st April 1981. But prior to 4th May 1985, the petitioner's husband, therefore, is entitled to pensionary benefits in terms of the provisions laid down in paragraph 2 of the memo dated 4th May 1985, as quoted herein above. The West Bengal State Electricity Board Employees Death Cum Retirement Benefit Regulations 1985, relied upon by the learned advocate for the EPF, came into operation subsequent to the memo dated 4th May 1985. Although these regulations have been made operative retrospectively from 1st April 1981, but the cause to receive pensionary benefits by the petitioner's husband had accrued on 19th April 1984. That is, prior to the regulations coming into operation, even though the same is made effective retrospectively. The petitioner's husband was entitled to the pensionary benefits immediately after the death in 1984. It is the only because such benefits were not given in time. The pensionary benefits of the petitioner's late husband remained pending when the 1985 regulations came into operation. The 1985 regulations, therefore, according to me, cannot be made operative in respect of the pensionary benefits of the petitioner's late husband, and it is the provisions of the memo dated 4th May 1985 which is applicable. It also appears from the letters issued by the West Bengal State Electricity Distribution Company Limited, in short WBSEB DCL, that an amount on account of family pension was deducted from the petitioner's husband, but the final accumulation towards family pension so deducted for being credited against the PF account number 126827 in respect of Mukundo Murari Pandey, being the petitioner's deceased husband, is not available with their records.
Volunteer.
The WBSCDCL has volunteered, my lord, has volunteered to deposit a sum of rupees 1,27,867 with interest at the rate of 12% per annum in respect of Mukundo Murari Pandey, the petitioner's deceased husband, to enable the petitioner to receive the family pension. The decision has remained pending as the Employees Provident Fund organization has not given any conclusive decision on the ground that the individual code number allotted to the petitioner's husband has not been provided. The matter pertains to the year 1984. The Provident Fund account number of the petitioner's deceased husband has been provided by the West Bengal SCDCL. The individual number may not be available. Deposit of Provident Fund amount which has been later on disbursed is also an admitted position. My lord, in the aforesaid facts and circumstances, I direct the respondent number 5 to condone all technical irregularities, if any, that may arise for non-availability of individual code number by permitting WBSCDCL to deposit the said sum of rupees 1,27,867 with interest as applicable against PF account number 126827 in respect of Mukundo Murari Pandey, the petitioner's deceased husband. The entire exercise shall be completed by 16th September 2022. After such deposit, the respondent number 5 shall take further steps to compute the current family pension payable to the petitioners along with heirs and disburse the same as early as possible, preferably before the Diwali for the year 2022. Let this matter appear on such and such paper. Needless to mention that the petitioner and WCL shall render all assistance and cooperation for effective carrying out the order. So this is the order, my lord. Lordship, my contention before your lordship is this, that first of all, we were not a party to the proceeding. We have been implicated later on during the course of proceeding, my lord, before the learned single judge. My lord, we have not assigned any code number. We have never received any money from the West Bengal state on their wrong submission. On their willfully they have made this submission that Provident Fund Department will pay the pension and other benefits, my lord. But this is not so. Because why I am showing? Because lordship kindly says, my lord, their own regulations, my lord, where there is a provision, my lord, that they will
come to that later. Tell us why you are not agreeable to this.
Only for this region, my lord.
Because they will be paying you the money.
No, my lord. Yes, my lord, there is a point. My lord, here, my lord, in EPS 95, the petitioner, the deceased member's wife will get only meager amount of, my lord, say about 2 lakhs or 3 lakhs, my lord. But they are, my lord, if they will calculate from 1984, then she will get, my lord, more than 22 lakhs and odd. There is the crux, my lord. They are not, my lord, I have highlighted, my lord, in my petition, your lordship, why I am saying so.
Tell us what is the controversy.
Controversy is, my lord,
come to page 60.
Page 60.
64.
64.
Please read the middle paragraph again.
64. Yes, my lord.
Go slow.
Yes, yes, my lord. In the aforesaid facts and circumstances, I direct the respondent number 5 to condone all technical irregularities, if any, that may arise for non-availability of individual code number by permitting WBSCDCL to deposit the said sum of rupees 1,27,867 with interest as applicable against PF account number 1268827.
Please explain to us.
Yes.
Why WBSCDCL is allowed to deposit this amount.
Only for this region, my lord, they are saying, but we want to comply. We have not, though we have not complied earlier, my lord, the 90, because they have their own scheme. On that scheme, they could have considered their case, but they have not. They didn't. But yes, my lord, that's my lord. That's very important, lord. Your lordship kindly comes to my lord. Page 38. Page 38. Your lordship would find, lord, page 38, my lord. Yes, my lord. It is, my lord, West Bengal State Electricity Board Corporate Office. Your lordship kindly, my lord, it's better to come.
So this, from this, that portion has been quoted, and the court held that in respect of the petitioner, that 85 regulations will apply, and not the provisions of the death cum retirement benefit regulations of 1985.
Right.
This is the
This is the,
contention
this,
of the
yes,
judge.
yes.
Now, if the previous regulation is accepted, is applied, then he becomes entitled to family pension. Yes. Now, please tell us, if he becomes entitled to family pension, then how much they are required to, because he was having a provident fund account.
No,
He's
my lord,
having a-
no, account number was, we had never, my lord, not the number of the family pension lot of the provident fund, statutory employees provident fund and miscellaneous provisions act 1952. It was their, my lord, the employee, and they used to deposit, my lord, with them. But with the West Bengal state WBDCL, my lord, state electricity board, not with the provident fund authority. How we have come in the picture?
His family pension became payable under the 1985
Regulations, my lord, with effect from 1981. And
That is your death cum retirement relief. Court
Yes.
said that will not apply.
yes, court has said notice.
Court has said that. Now, what I am asking you, that WPCDL was asked to deposit an amount of rupees, this quantum, where from the.
Yes, so how they have calculated, yes, no, that's the point, my lord.
Yes, sir. Can you explain? to
Yes,
us?
yes. What happened in this case, my lord, date of death of the original employee is very relevant in this case. Because my lord,
It
kindly
was prior to the memo.
prior to come into effect of the death cum retirement benefit, it is came in 1985, though it has been given prospective effect. What was the scheme prior to that? Because the original husband of the petitioner died prior to came that scheme, part 1985 scheme, because he was died on 1984.
20th April.
That scheme provides 1985, those who are entitled to get from that scheme, they will give option. In this case, my lord, the petitioner's husbands have died before that 1985 scheme. Therefore, he has not get any scope to give any options
Under the new
scheme,
that is death cum.
benefit scheme. Therefore, at the relevant point of time, what scheme they are applicable in the board, he was entitled to that scheme, that is contributory provident fund scheme. Accordingly, my lord, when the matter was came up before this, that after, my lord, that organization was taken over by PDCL. Initially, the writ petitioner filed the writ against the PDCL asking for pension. My lord, PDCL, my lord, that was, they have initially, my lord,
Who is PDCL?
PDCL is a Power Development
Bengal
Corporation Limited. That PDCL was informed the court that we have searched and the original employee was WBACDCL. Subsequently, PDCL was take over that unit. Then they have made the party the WBACDCL. And then the WBACDCL filed a report stating that the employee was our employee and he was in the contributory provident fund scheme. Accordingly, my lord, they have given the quantum of the amount which they are entitled to, because since 1984, there was no claim. Therefore, that amount was not given to them. The family pension, already it has been taken over by PDCL. The WBACDCL was not aware that person has died and their members, wife, did not claim any pension from the WBACDCL. Therefore, my lord, the courts directed to the petitioner to file appropriate application before the WBACDCL. WBACDCL, after receiving their application at the statutory form, after getting necessary formalities, sent to the PF authority for releasing the pension. They have asked for the court.
No, how pension? It will be
Family pension.
No, if contributory provident fund along with family pension.
Yes.
PF.
Yes. That was under the covered by the family pension, 1995 scheme.
Very good.
Nine-
After consideration of the representation, what order did you pass?
We have, my lord, no, they have, my lord, court was asked to do the necessary formalities in the forms which they will file before us, and we have forwarded to the Provident Fund Authority.
Where is that order?
That is earlier order, my lord. That is the order in the writ petition.
This is also an order in the.
Yes, but that order prior to that.
Which was that order? Now, what was the decision you take?
That we have, my lord, calculated the dues up to date, and we have, my lord, sent
To date means up to the
up to that
date
order.
of the employee.
Up date of the subsequently.
They person died in 84.
Person died in 84.
So from 84 till date.
Yes. We have calculated and we have sent that check to the regional PF authority. My lord, they now disputing that the code of the original family pension code, that 1984, there was no computer, my lord, computer code. That time, my lord, it is not available to us, but PF number is available to the WBSETCL. Therefore, my lord, we have stated in that, my lord, it is also reflected in the order that original family pension code is not available to us. Therefore, my lord, directed them to remove without any technical plea, my lord, they will take irregular, my lord, regularize the irregularities, whatever.
What is this PF account number?
That is with us, the original employees PF number.
126.
That we have get. Yes, that we have get. That we have communicated. This is the original PF number, but they are asking individual family pension code, which is not available to us because originally it was, my lord, WBCL. That thereafter, my lord, PTCL was take over that unit.
Individual family
pension code.
Why do they want that? Why do they want
that? We don't know, my lord. That's why court, my lord, directed to remove all irregularities and pay the family pensions.
Now this 1,27,867, how you have calculated this amount?
We have calculated according to, my lord,
This is the amount of family pension due and payable.
Along with that is, yes, due and payable to respect of his wife, my lord.
Now the family pension, monthly family pension, who will pay it?
Regional, because he has regional provident fund authority, he was contributory provident fund scheme.
Member of the
He was a member of the contributory provident fund scheme because before 1985, prior to that, all employees of the WB at the then board was under that provident fund scheme.
My learned friend is, my lord, mistaken, my lord. My lord, 1971 scheme was there. That was, my lord, abolished. Now family pension scheme, EPS scheme of 1995 has arrived. Your lordship knows, my lord.
Sir, how you are prejudiced by this?
Yes, but only for this reason, Lord, he is not in my employ. We have never received any amount from them. Now, Lord, one fine, how can we take, Lord, when we have not received, when we have not allotted code number?
With the order and the writ petition is pending, you are adjudicated, your claim will be adjudicated.
My lord, lordship conditions, my lord, when this order is impossible to be carried out, my lord, when
Possible.
because we have never, my lord, given any code number, we have not received any farthing from them.
What is the order? You have been asked to condone the technical irregularities.
My lord, the question of condoning the technicalities, my lord, will arise only when he is my member. He is the member of this fund.
Take away the amount after the writ petition succeeds.
My lord, can it be, my lord, your lordship, it pays 32 documents.
Mr. Prasad, how you are prejudiced?
My lord,
what the court has said that you are what is the dispute? For non-availability of the individual code. For non-availability of the individual code, you could not accept it.
But my lord,
now the court says that in view of the fact that it is a family pension, you accept the amount from them and you start disbursing the family pension in her favor. Now the lead petition has not been decided.
But my lord, one respectful submission, your lordship, page 38. My lord, kindly says the page 38, my lord. My lord, my submission is, my lord, why they are, my lord, shifting their responsibility or shifting their obligations on us just because to evade the actual amount, because they are, it is a known fact that if they will start giving, then it will be more than 23 lakhs and odd. I'm sorry.
Don't get excited. Acha, show us that 4th of May 1985 circular.
Yes, I was showing you, your lordship, page
That is
38.
page 41.
Page 38. I want to place this document. It is their document. Yes, to page 38.
of stay petition.
State petition, page 38, running page 38. That's not the, just circular. It is the 4th May 1985 circular, my lord.
Yes.
It is not the West Bengal State Electricity Board Corporate Office, Lord. This is not the from Sri S.K. Chakraborty, Secretary to all concerned, my lord. Now, subject, my lord. The West Bengal State Electricity Board employs death cum retirement benefit regulations 1985. Now, the West Bengal State Electricity Board employs death cum retirement benefit regulations 1985 as approved by the West Bengal State Electricity Board in its resolution number 20 dated 30th of July 1981 for the introduction of the scheme on an optional basis for the existing employees of the board and on a compulsory basis for new entrants, was forwarded to the state government for according sanction. The state government has approved the scheme with modifications attached here to by order number 277, such and such dated 20th March 1985, with the concurrence of the finance department, their EO number group R5 dated 16/2/85. The board has also adopted the scheme in its meeting held on 20th April 1985. The above mentioned scheme is applicable to all the employees of the board, with effect from 1st April 1981. The employees, irrespective of their date of appointment, are required to exercise option in writing in the annexed prescribed form Annexure 1 within a period of 6 months from the date of issue of this order, either for pension, including family pension, cum gratuity, or for contributory provident fund, cum gratuity. Option once exercised is final. Now, my lord, in case of the employees, very important, lord, in case of the employees who
Maybe only.
yes, in case of the employees who may be on leave on the date of issue of this order, the limit of 6 months will count from the date of their return from leave. Now, the board contribution together with interest, accrued hereon towards the contributory provident fund account of employees who will opt for the pension, including family pension.
You have omitted to one. Last two lines.
Again, my lord, who will opt for the pension?
Return from leave. Then in
Oh, my lord,
case
the
of,
board, my lord, I'm again reading it, sorry, my lord.
in case of an
The
employee.
board contribution together with interest.
Next paragraph here.
Ineligible
Previous
person.
No, last
Yeah,
Previous
you are
page.
not.
Oh,
The
achha, my lord,
last paragraph.
in case of an
oh, my lord, in
employment.
case of an employee
Yeah.
died after 1st April 1981, I'm sorry, my lord, this is a very relevant paragraph. Lord. In case of an employee who died after the 1st April 1981,
But before
but
the issue
before
of
the
this
issue
order.
of this order,
pension benefit.
pensionary benefits may be
settled.
settled at either of the rates which will be favorable to it.
So he can either go to CPF or he
or
can
GP.
come to pension. That he comes within that time, he could not exercise option because he died prior to
Option.
option could not. So apparently he becomes entitled to pension. Now the person has died. Family pension is to be paid to the widow. Now how the family pension is paid? His accumulation in CPF provident fund which was with them, they will give that amount to you. So that now you can commence payment of family pension on and from the date of receipt of this amount. They are not giving you any extra burden. They are saying that this is the calculator, petitioner does not object to that.
Yes, yes.
So they are paying. Court only has said that the only problem is that there is a technical fault as regards non-availability of the actual court number. But for that, neither the petitioner is responsible, nor you are responsible, nor they may be responsible. Court, in light of the family pension, has held that he becomes entitled to pension, come gratuity, come family pension. Please continue paying family pension. I am listing the matter. Next day I will dispose. So what is the problem?
But the problem is, my lord, yes, now your lordship has asked the very
No, no,
pertinent.
you are asking Mr. Prasad, what is troubling you? You are thinking that if today this is done, tomorrow a floodgate will be opened. Everybody will come and say, I had a previous number. Now you allow me to deposit. That stage has not come. That stage will be decided by the judge. But it is a beneficial scheme. The lady is dying. You give the family pension. You will have the record that how much you have paid. Suppose the writ petition will be taken up after 6 months. So 6 months family pension, maybe it comes to say 1.5 lakhs. So we will say whatever payment you will make, undoubtedly that will be subject to the result of the how you are able, sir. শুধু শুধু ঝামেলা করছো। আসো, the present appeal has been referred. The present appeal has been referred against an interim order dated 23rd August.
ও agree করছে কি করে?
ও তো টাকা দিয়েছে। Report my submission, not that they are not entitled to, as per my submission, as per my emergency.
Suddenly, Mr.
Your lordship, kindly, my lord.
You are bound to count. There are no number has been allotted and they have not deposited the amount.
Yes, and how then?
Yes,
My-
No, my lord, we said the check, but they have not accepted it.
So very good, give the check now.
No,
after the-
Already, my lord, my instruction is already, we have
We
sent
have
by
written back,
post.
we have written back to,
Huh?
I think, my submission, my.
Have they
already
accepted?
written back.
But that I don't know, but they have sent by post.
We have already written back.
Accepted.
No,
You
we
have
have not.
returned well.
I
Written
think
back.
not, subject to correction, not, it was not subject, but then if your lordship not wants, I can take instruction.
No, no, we will
No, no,
say
Written.
this order
Written
will not,
petition, oh, written back, he's saying that it has been written back.
so very good, he will send it back.
You will send it. Again. If they return, my lord, we are again comply that order. If they return the amount,
No,
I don't know.
He cannot give the same amount, your lordship kindly, my lord, kindly record that, my lord, whatever the actual calculation would
No, no,
be.
that will create, Mr. Prasad, that will create.
What that?
No, but my lord, lordship kindly says, not 1,27,000 he has calculated
Big
of its own.
interest up to that date.
Yes, I mean, it is his calculation, but not the calculation would be really done by the department, by the chief authority, where not whether it will be 1,27,000 or it will be more or it will be less, that will be decided.
Will pay the pension on the basis of this computation. If the calculation does not match,
No, if they will come to our, not EPS scheme, then whatever the benefits they require, then we will have to pay that. Not only we will restrict on this amount, key,
Only,
we will not restrict on this amount.
if it has been returned.
now we will. If it is returned, we shall again send.
Yes, not saying after calculation and all that, that will be done by the authority and
Without-
whatever the amount will come.
The authority will do it without
Because
calculation.
27,000 has been calculated by them. How they have arrived at that figure and all that, that is subject to
Mr. Prasad,
scrutiny and all.
that amount will not help you in any manner.
Yes.
Now you have to compute. Suppose you say that 1,27,000 has been paid. This is not the actual. Actually, it is 1,50,000.
That your lordship kindly will not, yes.
And, so in the final hearing, whatever.
Yeah,
they
amount
receive,
আমরা
they
যেটা
will pay the
ঠিক বুঝে বাকিটা ট্রায়াল জাজ তো
present appeal has been referred
পেনশন গ্র্যাচুইটি কবে দেওয়া হয়েছে
by National Provident Fund Commissioner
এই
who was implemented in the writ petition as the present appeal has been preferred, challenging an interim order dated 23rd August 2022. Passed in a writ petition being WPA 16893 of 2021. Mr. Prasad Named, advocate appearing for the appellant, submits
কি বলছে না আবার নতুন আমরা চেক তো পাঠিয়েছি চেক তো রিফান্ড করে
ard in law.
আমাদের
Learned single judge ard in law in directing the West Bengal State Electricity Board deposit an amount of rupees 1,27,867 along with applicable interest. Mr. Prasad Named, advocate appearing for the appellant, submits
আমাদের দিতে হবে
চাপাই দিব
learned judge ard in law in directing
তোমার ক্যালকুলেশন অনুযায়ী কত তোমরা
দিয়েছি ওরা
accept an amount of rupees 1,27,867 with interest and
from the date of
take further steps to platform the current family pensions.
I calculate করে plan ad hoc amount lump sum amount
তাহলে আলটিমেটলি কি হবে তা
আমরা ট্রাইজেন্স কে বলবো যে WPC release the offer give the family pensions per month by month along with the other amount এটাই করতে হবে আমরা অ্যাপিল করতে ভুল করে
ard in law in
ক্যালকুলেটর অর্ডারটা
to
that
accept
order to be complied with.
directing the appellant to accept an amount of rupees 1,27,800 with interest from WPCPF and to
take further steps
steps to compute the current family pension payable to the writ petitioner with arrears and to disburse the same. According to Mr. Prasad, WPCDL had admittedly not forwarded the PF account number.
number to this.
No, not the PF
Computer code.
That is family pension code.
Family pension code. I don't know. ভুল হবে PF account আছে
WPCL had admittedly
PF account individual
forwarded the
Individual code.
family pension individual
a individual code number pertaining to the writ petitioner's deceased husband.
yes
And in the absence of the same, and in the absence of the same, the appellant cannot be burdened with the liability to pay family pension.
And also not belong to the member of the family pension scheme as per pension scheme 1971. And also not member of the family pension scheme.
Mr. Prasad also has, Mr. Prasad further argues that the provisions of the
একাত্তরকে বাদ দিয়ে একান থেকে ঢুকে গিয়ে স্যার 81টা
71 scheme.
Mr. Prasad further submits that the rich petitioner's deceased husband was also not a member of the erstwhile family pension scheme of 1971. Right?
A scheme member of the fund created under.
Is also not a member of the fund created under the family pension scheme of 1971. Mr. Paja learned advocate appearing for the about the SCTCL submits that the entitlement of the petitioner towards family pension is clearly covered by the
By the memo dated.
by the memo dated 4th of May 1985. And as such, there is no infirmity in the order imputing the present appeal. Stop. Hardly learned advocates were appearing for
With the opposite party respondents, 3 and 4 lordship, 3 and 4 lordship. 3 and 4.
Mr. Hon'ble learned
Yes, Lordship.
advocate enters appearance
Yes, Lord.
on behalf of the respondent numbers 4 and 5.
No, lordship, 3 and 4 lordship.
5 here.
3 and 4. Lordship, I'm led by Mr. Ranjoy, my learned senior lordship. Lordship, I'm led by Mr. Ranjoy.
Mr. such and such learned advocate by Mr. appearance on behalf of hardly learned advocates appearing for the respective parties and consider the majority. The order repeats that upon arriving learned single judge arrived at a finding that the petitioner's deceased husband comes under the claim of the petitioner. The petitioner. Arrived at a finding that the proviso to comes under the falls within the ambit of the second proviso of paragraph 2 of the memo dated 4th May 1990. And considering the fact that the widow was not getting family pension, and considering the fact that the widow was not getting family pension, and that WPACT and WPACL had volunteered to invest an amount of 1,27,867 with interest in favor of the, in respect of Murari Pandey, আমাদের husband, directed the appellant to accept the said amount and disperse the family pension and to compute and disperse the current family pension and disperse the same. Stop. The learned single judge, upon arriving at a finding as regards entitlement of family pension, entitlement of the petitioner towards family pension, directed the appellant to condone technical irregularities and to disperse the and to compute and disperse the family pension. Stop. The order further depends. The writ petition is still pending and all issues in the same would be urged by the parties at the final hearing of the same. Final hearing of the writ petition. Stop. We do not find any infirmity in the interim direction. Find any infirmity in the order dated or the interim order dated 23rd August 2012, and as such no interference is called for in the present appeal. Stop. Accordingly, the appeal and the connected application being can 1 of 2020 are dismissed. Stop. There shall, however, this next.
Disposed of.
Not dismissed.
Lordship is clarifying something, Lordship. It would be disposed of. Not dismissed. It would be disposed of.
Why? The court has not interfered with this.
What is before us?
I'm sorry. I'm sorry.
It would be disposed of because your Lordship is saying your interim arrangement.
You are already a famous advocate, so dismissal or disposal. Yes, next. Yeah, what 3 PM fixed matters.
Other matter release.
Release हो गया. Wait with us. Yes.
আর ওদের যে পয়েন্ট গুলো সেই পয়েন্ট গুলো Lord, give me 1 minute time.
You have finished.
No. I did not finish. I was in midst of my argument. আমার যে নোটটা এই তো Lord, yesterday I had submitted Milord on. I'm sorry. List of ওই যেটা বানাচ্ছে ওইটা দিয়ে এইটা বার করুন কাটার কিছু নেই আস্তে আস্তে এইটা আপনার
এইটাই ঠিক আছে Yes.
ঠিক করুন আমার তো আর আদার সাইড কি কথা Lord, in addition to the list of dates, Lord, I have also prepared a list of Lord all the litigations pending between the parties. Lord, only which one mention?
এটা তো 87
এবার দেখে নিচ্ছি
Yes.
Lord, in addition to the list of dates, Miller, I've also prepared the list of litigations, Lord, that have been pending. The Lordship wanted, Lord, that's why I prepared.
That title suit has nothing.
No. Rest, Lord, everything is taken care of in the list of dates itself, I suppose.
When
Lord,
you have prepared, give us
Uh,
your copy to Mr. Bennett.
yes, add a copy. Yes, sir. Sorry, Lord, it's in the A4 paper, Lord. Kindly excuse me.
I'll give this. Yes.
Lord, yesterday I had made my submissions on the scope and ambit of 383 and its application on Lord, the arguments made by Lord, my senior friend. Lord, I had also argued, Lord, the nature and scope, Lord, of operation of this res judicata argument, which I'll also try and develop when I Lord proceed with my arguments. Lord, the other aspect of the matter was I indicated to your Lordship, Lord, that the manner in which the deviation has been made from the demolition order itself. Lord, one more thing I will just indicate, Lord, yesterday it was omitted from my part. Kindly comes, Lord, to the demolition order once at page. Demolition order page kota? Eta konta diki?
Yes, 47.
My lord. Lord, kindly turns over. Lord, the major deviations according to me are 2, 3 and 4. These are the major deviations. The reason are, although Lord, the width of the construction might be very small, but because of the length, the deviation is more. Lord, it's a massive deviation, according to me, subject to what Lord, your Lordship considers. Lord, the other aspect of the matter is, Lord, item number 5. This position of septic tank is shifted from back side to the north side of the building. Because of this shift, there is an immense foul odor always coming to my bedroom. Here is my bedroom shifted. My bedroom is there, located, situated. That's why in the building sanction plan, they were given the position on the rear side of the building. They shifted it to the northern side. That is one.
What is your next argument?
Yes. Lord, once judgment was cited, that is 1974, volume 2, SCC 121. Found, Lord, that when a statute my
That is on the purpose of nullity.
nullity. Because if the statute contemplates notice to be given, if it is not given, what is the effect?
Hearing not.
Yes, hearing, notice on hearing.
Inquiry report.
Mild. Then in that case, it will be a nullity. Lord, kindly considers paragraph 3 and 4 of this judgment, based on which I'll try and distinguish this judgment to the present case of the
1974.
Yes.
Yes.
Lord, paragraph 3. An externment order was issued not in this present case, in this 74 case. The externment order not preceded with an obligation of notice and the paraphernalia how the proceedings are to be held. That was stated in the act itself. Kindly consider violation of natural justice is the vice of the order which was defied by the accused. We will first set out the relevant provision of the such and such unnecessary provision, section 56.
whenever it shall appear in Greater Bombay and other areas of which commissioner has been appointed under section 7 of the commissioner, and in other area of the areas state government may by notification in official gazette extend the provisions of section of this section to the district magistrate such and no, just to
Which point you are suggesting?
No,
His
I'm-
argument was simple, that if I can establish that natural justice needs to be read into the rules, inquiry report ought to have been given to me. As it was not given, order is an annul.
my argument to that was, my lord, the act does not require an inquiry report to be forwarded.
That you have
That was,
said.
yes.
that you have
Now, my lord, to substantiate that, I have to distinguish his judgment on the ground that what was the consideration before the Honorable Supreme Court, based on which this judgment was
said
delivered.
that you don't have to need.
No, the facts, I'm not reading the entire, only the facts. Why, in which situation this was done. That's why I precised my argument on paragraph 3 and 4. Those are recording the facts. District Magistrate of Subdivisional Magistrate specially empowered by the state government in such and such movements. No, this is the section 58. Thereafter, straight away comes to paragraph 4. 59 was very important. That 59, section 59 in that act. Paragraph 4. Before an order under section 55, 56 or 57 is passed against any person, the officer acting under any of the said sections or any officer above the rank of the inspector authorized by the officer shall inform the person in writing of the general nature of the material allegations against him and give him a reasonable opportunity of tendering an explanation regarding them. If such person makes an application for the examination of any witness produced by him, an authority or officer concerned shall grant such application and examine such witness, and thereafter, my lord, how it is to be done was said. This is conspicuously lacking, my lord, in the provisions of either section 287 or section 266.
Where is section 55, 56, 57?
Lord, that's why I placed, my lord, before this paragraph 3. 56 has been quoted there. 55, 56 and 57 whereof.
6, where is the offending portion?
Yes. Whenever, paragraph 3, my lord, kindly got it?
Yes.
Whenever it shall appear in Greater Bombay and other areas for which commissioner has been appointed under section 7 of the such and such, and in other areas by notification in the official gazette, extend the provisions of this section to district magistrate or divisional magistrate specifically empowered by the government such and such. Danger or harm to person or property, that there are reasonable grounds for believing that such person is engaged in or about to engage in the commission of an offense involving force or violence. So we'll have to prohibit a person from entering into an area, some order was to be passed. That order could not have been passed without complying with the provisions of section 59.
Was that portion that this was required?
Yes.
Provision of giving a writing.
Yes.
Reasonable opportunity.
Kindly comes to paragraph 4 once again. Before an order under section 56, Lord, 55, 50 is not important. 56. Passed is passed against any person acting under such and such above the rank of inspector authorized shall inform the person in writing of the general nature of the material allegations against him. So, Lord, paraphernalia was set because of the nature of the order that was going to be passed. Here, this is conspicuously absent in case of either 287 or 266. Kindly, my lord, 287. Yourself, 2006 2006. Bengal Municipal Corporation. Lord, first, may I take your lordship to 287? Your lordship has gone into it. Only I'll indicate, Lord, the
Section
287 after, my lord, subclause C.
that is absent. Inquiry report absent, but reasonable opportunity of
Only a reasonable opportunity may be given. How it is to be given, that is not given.
provided. Only a reasonable opportunity. Now, Lord, why I took your lordship? In 66 also, my lord, the same thing.
Preceded by the order of.
Absolutely. Now,
Preceded by the order of inquiry.
now, Lord, my argument with your lordship is the filing of the writ petition seeking demolition was itself a notice. He participated in that proceeding. The order was passed in his presence. In that order, kindly sees, Lord, ওই ইয়ের পেজটা বল 14 2014 order. হ্যাঁ, Lord, kindly comes to page 41.
Yes.
Kindly comes to page 41, 41 of the Lord Can 1 of 1988. Mat 19.
You have to show anything else from the 74 judgment?
Lord, this is for my respectful submission. This is good enough, Lord, for distinguishing on facts.
Yes. Page 41.
Page 41.
Yes, what is that? Yes, that has been placed.
Lord, not the entirety was placed. Having heard the learned advocates for the parties.
One was not placed. Tell us which
Yes.
portion.
Lord, your lordship, 8 weeks from passing reasoned order, your lordship has seen.
Yes, yes.
To be communicate parties after giving opportunity hearing petitioner and private response 6 and 7 verifying records, including the sanction plan, if any, and after causing inspection site parties. At the time of hearing, the private respondents are at liberty to file written objection to the complaint dated such and such, and the Board of Councillors in reasoned order this. This written objection was again never filed. So, my lord, the question of natural justice was secured by this honorable court. The issue of natural justice that they were not heard. I'll come to my argument that I made yesterday, my submissions that I made yesterday, that it will be only a mere formality, nothing more than that. 2015.
Please don't repeat that argument.
Sure.
We have taken note of it.
Yes, Lord, I'll only, to fortress my argument, Lord, I'll only cite one judgment. Now, this paragraph is, this is 2015, volume 8, SCC 519, paragraphs, my lord, 8, 44 and 45. Page 519. 15.8. Lord, the notes, nature, scope, applicability, flexible nature of principles of natural justice, absence of any straitjacket formula, useless formality test of prejudice. That is what I argued before Lordship yesterday. Lord, just to indicate the facts, Lord, this was under an order passed under the Lord Central Excise Act. Lord, under the Central Excise Act, Section 111A contemplated of a similar situation that before passing an order, you have to give a reasonable opportunity of being heard. That was the order passed. Paragraph 8. From the brief narration of the background facts mentioned above, it is apparent that the frontal attack of the appellant against the recovery orders passed by the respondents is premised on a plea that no such recovery proceeding could be initiated without a show cause notice under section such and such. The appellant has also taken a plea in these appeals that order of the single judge at prerequisite stage could not operate as res judicata on merits, and therefore dismissal of tax such and such review petition was clearly erroneous. So, same line of argument that it is because it was not complied, so res judicata does not apply. Kindly straight away, I'll not bother your lordship with the entire. The arguments and reasoning before the Honorable Supreme Court was that only because it will be a useless formality, the authorities cannot take the baton in their own hands. That is the law settled. Considering that argument, the Supreme Court observes. At the same time, it cannot be denied that as far as courts are concerned, they are, kindly got it, paragraph 44. They are empowered to consider as to whether any purpose would be served in remanding the case, keeping in mind whether any prejudice is caused to the person against
whom the action is taken. This was also so clarified in such and such. Hence, not the quotation based on which the judgment comes. Hence, in all cases where the inquiry officer's report is not furnished to the delinquent employee in disciplinary proceedings, the courts and tribunals should cause the copy of the report to be furnished to the aggrieved employee if he has not already secured it before coming to court, tribunal such and such, to show how his or her case was prejudiced because of the non-supply of report. If after hearing the parties, the court comes to the conclusion that the non-supply of the report would have made no difference to the ultimate findings and the punishment given by the court should not be interfered with the order of punishment, the court tribunal should not mechanically set aside the order of punishment on the ground that the report was not furnished and is regrettably being done at present. The court should avoid resorting to shortcuts, since it is the courts which will apply their judicial mind to the question and give their reasons for setting aside or not setting aside the order of punishment. There would be neither a breach of the principles of natural justice nor a denial of the reasonable opportunity. It is only if the court that the furnishing of the report would have made a difference to the result in the case that it should set aside the order of punishment. Keeping in view the aforesaid principles in mind, even when we find that there is an infraction of the principles of natural justice, we have to address a further question as to whether any purpose would be served in remitting the case to the authority to make fresh demand of amount thereafter. This is the case set.
Yes.
Now, why I say this, my lord, that no purpose would have been served. Lord, paragraph 11, your lordship.
Mr.
Lord,
Governor, come to the next point.
Lord, only to show, Lord, your lordship wanted me
We
to.
have understood your point.
Lord, your lordship wanted me to show the paragraph from where the impugned order has quoted, my lord, paragraph 11 of that writ petition. I have brought that.
That is a separate.
Yes.
That you are speaking about the admission.
My lord.
Yes. Anything else, Mr. Governor?
Just one. Give me, my lord. I'll not take much time. Paragraph 11. I only have one copy, my lord. Paragraph 11 is the WP number 7672. This is their writ petition. This petition was withdrawn. So, my lord, by asking regularization, he is admitting, my lord, illegal construction. If he is admitting illegal construction, no purpose would have been served.
It was a minor difference.
According to him, Lord, that the corporation adjudicated otherwise. Lord, kindly also seize the prayers, my lord, of this writ petition once for my satisfaction. I'll indicate why. Lord, this is also an order of 12th of January 2018. Your lordship wanted me to, Lord.
Just finish up with the prayers.
Your lordship, in the prayers, your lordship would find the same challenge, Lord, with respect to the protection and seeking, Lord, regularization. So, Lord, this was withdrawn. Once this was withdrawn, Lord, the scope and ambit of Order 23, Rule 1 squarely applies. The judgment of it. Without liberty. Paragraph.
Yeah, 1987 Supreme Court page 88.
হ্যাঁ ওই একই আমি এসসিসিটা দেখাবো।
Yeah, 1987 SC 88 Sarguja Transport.
Look, this is 1987 1 SCC page 5. Relevant paragraphs are, my lord, 5 to 9. I'll not, Lord, bother your lordship with the entire. Hmm? 5 to 9. Lord, paragraph 8, I'll just indicate nothing more than that. Your lordship, Lord, knows about this judgment. The question for our consideration is whether it would or would not advance the cause of action, cause of justice if the principle underlying Order 20 Rule 1 of the code is adopted in respect of writ petitions filed under Article 226 of the Constitution also. It is common knowledge that very often after a writ petition is heard for some time, when the petitioner or his counsel finds that the court is not likely to pass an order admitting the petition, request is made to the such and such, my lord. Those are facts recorded. The point 9, the point for consideration is whether a petitioner, after withdrawing a writ petition filed by him in the High Court under 226 without the permission to institute a fresh petition, can file a fresh petition, writ petition in the High Court under the article. On this point, the decision of such and such is of no assistance, but we are of the view that the principle underlying such and such should be extended in the interest of justice of administration of two cases.
The trial judge did not dismiss the writ petition on the ground of withdrawal of the earlier writ.
But that was also a consideration there.
Maybe a consideration.
Lord,
Then
I-
you have not preferred any appeal against that finding.
Lord, even if my respectful submission,
You have to choose your way, na. If you say order 23, rule 3, barred, you have to show us that only on that point the writ petition has.
no, that was my argument. And my lord, your lordship,
But whatever it may be, that argument was not accepted because the writ petition was not dismissed on that ground.
Lord, I can,
Dismissed on
in
the
appeal,
other ground.
subject to correction, my lord, in appeal, your lordship I made this
So
argument.
this is not your appeal, Mr.
Even if it is not my appeal, as a respondent, I can raise this point.
Raise it, we are hearing.
Lord, I'll just indicate the provision also, Lord, I can raise.
It is like beating about the bush. The point is, Mr. Banerjee's argument was order 23 did not detain him for a further time. He directly went to the merit because the writ petition was decided on merit. Not on a technical
Lord,
ground.
that's the reason I'm indicating that the writ petition should have been also dismissed on this ground as well.
Alright.
On this ground as well.
Yes, next.
Lord, there are 2-3 things, Lord, kindly
You have
comes.
already taken for half an hour, I suppose. You said 15 minutes.
Lord, I just started, Lord, I'll just take 5 minutes more.
Yes.
Lord, kindly comes to page 9,
Of the
paragraph 9, I'm sorry,
para
of
nine
this, Lord, can 1. This is to show, my lord, the manner in which the case is being conducted.
para 9.
Para 9.
Yes.
Lord, kindly sees on the, this is four lines, Lord, from the top. That is in paragraph 9, 4 lines from the top. On the said date. On the said date, by an order dated such and such, the said honorable single judge, upon noticing section 218 of the act, did no longer apply in view of Gopalpur municipality having become the BMC, directed the commissioner of BMC to file a report how he proposes to comply with the said order. Now, my lord, kindly comes to page 43 once. Nowhere in the order, my lord, the purport of this section, paragraph 9 is evident. The court records that corporation has formed, 218 does not apply. It clarifies the affairs of new municipal authority are controlled by the 2006 Act. Then also no objection raised. হ্যাঁ বলছি তো পুরোটাই দেখাবো. So there is a finding that act did not apply, this act applies. Now the commissioner was directed, you still did not conform to the directions. Now you propose how you want to do it. And my lord, after this, 2012 যে অর্ডারটা 12/1/2000 Lord, your lordship wanted me to, Lord, refer to the order dated 12th of January 2018 that forms the basis, Lord, of the Lord. That is basically, Lord, repetition of, Lord, the order passed in 2017, extending the time to file report. Now this, in the site, it is not available. I have obtained it from Lord,
No, that.
the other website. This order is the basis of the demolition order. This order is the basis of the demolition order. In pursuance of order dated 12th of January 2018, the demolition order starts.
Now, this final official report was communicated.
That was after this order, it was communicated because the demolition order is just after that. It is 9th of February 2018, the demolition order.
See, file their final official report.
Yes.
That is the demolition order.
My lord. And
Now,
thereafter,
the inquiry report which was prepared, was it given to you?
Lord, I've taken instructions, I have also not received. Lord, I say that neither it was required under the law, nor could it make any difference, even if the inquiry report was given. Lord, the other paragraph is paragraph number 20.
Paragraph 20.
My lord. So, my lord, that is again a wrong statement, if I may use that word, in paragraph number 9. Para 20, meanwhile, the respondent number 5 filed yet another writ petition, being the present one, in the teeth of the pending contempt application.
Paragraph?
Not paragraph 20, 20.
Yes, what you are showing?
Lord, yet another writ petition, being WPA number such and such, in the teeth of the pending contempt application, being CPAN number 2296 of 2014. Lord, kindly see, Lord, 2014 from the list of Lord the litigations I just handed up, Lord. Kindly takes that once. In the second Lord row, CPAN 2296 was disposed of on 2019 itself. Immediately after Lord, the order was communicated or given. With a liberty I shown your lordship yesterday, Lord, that is page 52. That is page 52, disposing of Lord the first contempt and giving a liberty for initiation of the second contempt. So, Lord, this is again an incorrect Lord recording. Lord, these are only points, Lord, just to indicate to your lordship, nothing more than that. The last Lord contention, that is section 266 and 287 was requirements of 266 and 287 was never complied with. That was the last submission, which ultimately renders Lord the judge order passed to be a nullity and all. Lord, to that my reply is Lord that substantial.
You said 383.
383, Lord, 383 was saving the application of 1993 Act. That was the application. Here, his my learned senior friend's argument was the requirements under 266 and 287 of the 2006 Act was not complied with. If the requirements are not complied with, then the ultimate order that was passed is a nullity. To that, my argument, my submission, respectful submission before lordship is that the requirement of this section is to give them a reasonable opportunity, not a notice. The notice was there with them immediately upon filing of the writ petition. Upon the order being passed, they participated in the proceeding. They filed the building sanction plan. Inspection in their notice, never objected to. They admit that they had made deviations. So, Lord, after all these admission and entire chain of events, if the substantial compliance of the sections have been done, then in my respectful submission, Lord, only because I was not given an inquiry report, which would have ultimately could not change, Lord, the effect of the order is of no consequence. So, Lord, to sum up the matter, Lord, the first argument, my first submission, is with respect to Lord 383, the application of 383. So that thing goes. Lord, the second point is with respect to principle of natural justice. The test of prejudice has to be applied. and in this case, they are not prejudiced at all. Thirdly, my lord, compliance of 266 and 287. I have shown to your lordship substantive compliance was done. So, my lord, there is no violation of either the provision or natural justice. And fourthly, my lord, with respect to other aspect of application of Order 23 Rule 1 and misleading, my lord, the statements made in the affidavit itself, my lord, these are my respectful submissions, your lordship. আর কিছু বাকি?
Yes, Mr.
Oh, Lord, before only one point, Lord, the last submission, that is, Lord, your lordship is sitting, Lord, the lordships are sitting, Lord, in an intercourt mandamus appeal. The scope for that, Lord, 2019 1 CHN 328. Paragraph 22, 23, 34 to 37. Your lordship has considered this, my lord, earlier also. Page 328. (22, 23, 34, 35, and 37). In normal circumstances, while deciding intra-court mandamus appeals, nitty-gritties of findings and niceties of law, let alone fact, are generally not looked into. Interference, paragraph my lord, 22, 23, 34, 35, and 37. Your lordship, my lord, has gone into this judgment.
Yes, yes.
Lord,
Mr. Gordon.
I'll not multiply. Sorry.
Lord, at the outset, my lord, I'll beg your lordship's pardon because some points may seem to be similar because Mr. Kormakar has argued it, my lord, extensively. But my lord, only on 2 counts, though my lord, my end result of the argument may be the same, but on 2 counts, I am not agreeable to the reasoning given to the court, my lord, by Mr. Kormakar. Firstly, my lord, is the Mr. Banerjee's argument with regard to nullity. If I have understood correctly, Mr. Banerjee's argument was that the section 266 speaks about a sanction plan under section 263. The plan being not under 263, the jurisdiction was not with the commissioner. Therefore, the order is a nullity, and therefore he has relied on the division bench order, my lord, in Bina Shaha. And my lord argued that the order is a nullity and I can challenge it at any point of time to overcome the point of Order 23, Rule 1, Sub Rule 4. Now, my lord,
Let us come to
266.
66, 267, and 287.
My lord, his point was that if your lordship kindly takes 266, if I have understood correctly, Mr. Banerjee will correct me if I am wrong. He says that if your lordship kindly takes 266, he says that 266 applies where the erection of any building or the execution of any work has been commenced or is being carried on or has been contemplated without or contrary to the sanction referred to in section 263 or in contravention of any provisions of this act. Mr. Banerjee repeatedly said, pursued your lordships to stop at this part of the section because according to him, 266. Because according to him, his plan not being under 263 of the 2006 Act, because it was much prior in time under the 1993 Act, the commissioner did not have power to go into, to exercise this. My lord, here, I agree with the argument of Mr. Kormakar, but the section he relied is 383. Here, I'd like to draw your lordship's attention to, my lord, section 403, 2D. That is the actual saving clause here. The action taken there pertains to legal action and suits. Can I take 403 2?
Section
403, subsection 2D. May I please subsection 2, Mala?
Yes.
Notwithstanding the provision of subsection 1, the so and so, 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 constitutional so and so, or Durgapur Municipal Corporation Act so and so, as the case may be, shall, with the effect from the date of commencement of the act, be deemed to have been constituted under this act and in respect of every such corporation. Every budget passed, loan taken, assessment made, buildings plan sanctioned, license or permission or sanction so and so granted under the West Bengal Municipal Act 1993 and in force immediately before the commencement of the act, so be deemed to have been passed, taken, made, sanctioned, granted under this act. So the plan sanctioned under the 1993 Act shall be deemed to have been passed under the provisions of this Act, meaning thereby the plan sanctioned under 1993 Act will be deemed to be a plan under Section 263.
Yes.
And therefore, the commissioner will have the power that where the erection of any building or execution of any work has been commenced or is being carried on or has been completed without or contrary to the sanction referred to in Section 263 or in contravention thereof, in addition to any other action that may be taken under this Act, may make an order directing that such erection or work shall be demolished by the person at whose instance the erection or the work has been commenced or is being carried on so and so. Now, my lord, the question of notice. Now, my lord, Mr. Kormakar has already argued, my lord, I would have argued the same point, but I'm not repeating, that the question of notice or putting someone of notice, but the purpose is that the person should not be prejudiced. My lord, here, if your lordship kindly takes page 45, page 45 of Can 1 of 1988. In compliance of the order dated 20th January 2017 of the Honorable Court, a physical inspection will be carried out in connection with the illegal construction on so and so by the engineers of this corporation. So you are requested to be present with all relevant documents. And pursuant to that, my lord, the order records at page 47, fourth paragraph, that in compliance to the orders of the Honorable High Court dated 20th January 2017, read with SIP and so and so, a physical inspection was carried out by the officers of the Bidhannagar Municipal Corporation on 20th February, which was duly intimated to the parties with a so and so, and during inspection, the following deviations were found with the sanctioned building plan number so and so, dated so and so. Now, my lord, they say that the inspection report has not been given to us. Now, my lord, that is of no consequence, my lord, because 2 pages, my lord, of the writ petition has been placed before your lordship. But the writ petition from which this impugned order has been passed, in which that is not annexed to the stay application. But I have the entire writ petition also, but I have only, my lord, extracted a few pages. 2 of them has been placed by Mr. Kormakar before your lordship.
Paragraph.
That is, one is paragraph 11 in the writ petition, concerned writ petition, that is at page 85. And the prayer has been placed, which is in the concerned writ petition at page 94.
What you are showing.
Well, I am showing some other pages from the writ petition in which the impugned order has been passed. His writ petition.
Yes, sir.
That is writ petition number 15950. দুটোই আছে না না কোনো একটা চলে কোথায় ও সরি
This demolition order was on the basis of 2128 of 2014. So Justice.
Yes. Yes.
Now this writ petition is.
This is his second writ petition, her second writ petition challenging the same order. Because in the earlier round, order challenge was made, it was withdrawn without any liberty. That is why the question of order 23, rule 1, sub rule 4 comes.
15950.
15950 in which the impugned order has been passed. Now, my lord, 2 pages have been placed. Page 85 has been placed where paragraph 11 is there of the first writ petition. And page 94, prayer B, is the prayers in the earlier writ petition. Your lordships will at the same time kindly take page 90, which is part of the extract I have given. That is their ground 4. For that, the commissioner passed the order of demolition without giving the chance to explain the essentiality of the deviation. They wanted this chance of hearing to explain the deviation, but the deviation is admitted. Then, page 92. 92 টা কোথায় গেল? Ground number 18. The commissioner passed the order subjectively without appreciating the fact that there is a scope for regularization of the deviated portion as alleged by the provision of the municipal law. Malad, I say that there is no provision of regularization in the Act of 2006. And Malad, in the private respondent's writ petition, the appeal which was preferred, which was also Malad dismissed by your lordships, which was for demolition of the private respondent's construction, we have already said that by way of an affidavit. At that time, both the matters were clapped together and taken up together. On affidavit, we have said, copy that is MAT 1431. On affidavit, we have said that there is no power of regularization.
1431 of
Or 2022, in which Ganesh Patra is the appellant.
what is the date of the order?
Malad, date, order date. Malad, I'll supply the date in the meantime. Malad. Yes, Malad, this is the affidavit which was filed by us.
You said that we don't have any power to
Regularize. We have said that on affidavit. But this is the other one is a bit marked, Malad. In paragraph page 3, paragraph 7. It is further stated that assuming but not admitting that the said unauthorized construction has been duly regularized by the erstwhile municipality, the same is non-est in the eyes of law as neither the Municipal Act 93 nor the Municipal Corporation Act 2006 or the rules framed thereunder has the provision of regularization of any construction made in deviation of the original sanction plan.
What did we do with that?
But Malad has dismissed that appeal. And Malad, that was Ganesh's appeal against the order of the Honorable Single Judge, in which the Honorable Single Judge directed demolition of his premises on the complaint of the appellant hearing. Ganesh constructed an additional floor.
Yes.
But I am not on how much they did or what they did not. What the question is that the admission or in the writ petition, which is not annexed to the stay petition. They found out so many admissions, they avoided the entire writ petition. Then kindly take page 98.
He has not suppressed it. Said. Yes.
90, sorry, Malad, kindly takes Malad page 102, Malad, in the extract that I have given. This is their appeal before the mayor. 102 in the extract of the writ petition I have given, Malad. In that, 102 pages there.
Yes. Yes.
Malad, your lordship will find in the appeal to the mayor, which is also non-est in the eye of law, kindly see their grounds taken. The commissioner passed the order of demolition without giving a chance to explain the essentiality of the deviation.
The repetition.
Yes, and same Malad at 104, round number 18. There is scope to regularize. Now, Malad, another order which I have in the extra, in the stay application is also there. Malad, your lordship has seen, Malad, Mr. Kormakar has placed that. So, Malad, in the erstwhile writ petition, Malad, the same order was under challenge. It was withdrawn without, Malad, any liberty being reserved. And Malad, Malad, subject to correction by your lordship, Malad, that was in fact one of the grounds taken by the Honorable Single Judge in dismissing the writ petition. If your lordship kindly bears with me, Malad, and takes page 102 of the stay application, which is the internal page 12 of the impugned order. That is in fact one of the grounds but considered by the Honorable Single Judge. But we'll kindly take (102) second paragraph onwards. Well, second, third, fourth paragraph of page 102.
Last two lines.
Matlab,
Last two lines.
yes. The bar is applicable so and so to the 226 also. It is highly improper to reopen an issue which has already been settled and attained finality by the passage of time and also by the subsequent acts of the parties.
Then why did the court go into the other point?
But it went into, it was argued, it was extensively argued at that point also. But it is one of the grounds also taken in the impugned order. Next, Ballot, is the point of delay, which has been also been considered by the Honorable Single Judge from 103 onward. Ballot, if I may hand over Ballot, another set of list of dates we had prepared. There's another copy. But first, kindly takes page 103.
Page 103.
3 of the stay application, the point where it has been taken. Internal page 13. It is surprising to note that even though Shobita preferred appeal before in an appropriate forum in July 2018, but thereafter she did not proceed to pursue with the appeal. She merely filed the same and deliberately kept it pending with the oblique intention to take advantage of filing of appeal at an opportune moment and shift the burden upon the corporation in not taking steps to dispose of the same. During the interregnum between 2018 and 2022, several other proceedings came to be initiated by Ganesh, praying for implementation of the order of demolition. Had Shobita been genuinely aggrieved by the order of demolition, then she ought to have proceeded with the appeal in its right earnest and not merely file the same and leave it unattended. Shobita, however, was successful in getting the unauthorized construction of Ganesh demolished. The appeal was preferred beyond the prescribed period of limitation, along with an application praying for condoning the delay in preferring the same. The Shobita never cared to press the application for condoning the delay, and as such, it can safely be concluded that the appeal has been formally registered in the eyes of law. No appeal has been formally registered in the eyes of law, and as on date, no appeal has been preferred against the order of the demolition. And my lord, after all that, my lord, only in 2022.
Sorry, we didn't follow you. What did you say?
My lord, 103, my lord, third paragraph. It says that the appeal was preferred beyond the prescribed period or limitation.
Which appeal?
My lord, the appeal for the mayor. Though honest in the eye of law, the honorable court records that even that is belated.
Twice.
And they kept it pending. They never asked for a stay that do not proceed with the demolition. No steps were taken. And even assuming that 2018 in the erstwhile writ petition, they should again get an opportunity, irrespective of Order 23, Rule 1, Sub Rule 4, to press the point again. That is also after 4 years from the date on which the demolition order is passed.
17th July.
This stay application they have filed, in the writ petition at page 114, it is filed on 7 July 2022. That is at page 114 of the writ petition. The stay application they have filed that do not demolish it, stay your hands from demolishing before the mayor.
Before
the mayor, that is filed on 7th of July 2022. And that is why the Honorable Single Judge has recorded in page 103 that during the interregnum between 2018 and 2022, that is what
is the date?
says 7th of July 2022.
And the appeal was of July 2018.
2018. 31st July 2018. Almost after 4 years, they file a stay application. That is why these two dates are appearing in the order, because those were part of the writ petition. Now, my lord, in view of my
Yes.
well, in view of my first point, my lord, that the power being there under 266, the question of nullity and the reliance on Bina Shaha, that is in MAT 1325, my lord, that Bina Shaha is distinguishable on that point, my lord, because there my lord, the honorable division bench held that my lord, in internal page 6, that we are in agreement with Mr. Banerjee, as we must be, since it is established law that a defense of an order being a nullity can be set up by a person against whom such order is sought to be enforced at any stage, irrespective of the length of time that may have passed from the date of passing of the order, so and so. So that is the finding. So this finding is not applicable in our case. So Bina Shah Malad is highly distinguishable. And Malad, as far as the other point of prejudice is concerned, Malad, my arguments are same as Mr. Kormakar, that when they admitting the deviation from the sanction plan, Malad, nothing remains, Malad, to be said in a hearing. What they wanted to say, they expressed themselves that we want to justify the deviation when the deviation itself is admitted. The question is not a minor deviation or major deviation. They are trying to project it like a very minor deviation, but if it is minor, it may be removed. That is the way I am looking at it. And your lordship can see, my lord, at page 47, the extent of deviation by no stretch of imagination, my lord, can be said to be minor deviation. Especially, my lord, point number 3.
That the commission, that the authority could have mentioned,
But it is mentioned
not that there is no line, so that whether it was major or minor has been
my lord, the act itself does not distinguish between.
your argument. You say immaterial whether minor or major, but
No,
see the major.
that I am saying this, my lord, because this argument has been made that what we admitted in the writ petition was with regard to minor deviation. That is their case. If your lordship kindly sees page 47.
Case was that from the order it is evident that the commissioner proceeded on section 287. But there was no application of mind as to this issue, that whether minor or major. Had it been a minor question of regularization, now judicial precedence. Now the judicial precedence. That this is a minor deviation, already in the facts of the case you regularize.
Yes, that is why, my lord, I
Our argument to that is that we don't
have that power of regularization. So that is why the question of minor deviation and major deviation cannot arise. Or that application of mind, that whether it's a minor deviation or major deviation deserving regularization, what is not permissible under the statute, but going into that aspect and application of mind there, but that expectation of the appellant is also not correct.
Yes.
Very short reply. I'm sorry, my lord, for having elaborated or repeated yesterday. I promise to be
Part of the play.
I promise to be slicker today.
Advocates always try to
Emphasize a point by
emphasize.
I'm sorry if I have repeated, my lord.
Why you should be sorry? We already told you our reaction. Sorry, our yes.
I started and I based my entire argument substantially on nullity, because nullity would take care of all my ailments. What was my submission, my lord? Without elaborating it again, my submission was that the order of the municipal commissioner is a nullity on multiple counts, and these are independent multiple counts. Count 1, that the municipal commissioner could not have exercised jurisdiction under section 287, read with section 266. Why? Jurisdictional facts absent. I will deal with the 2 sections shown to save it. I will deal with it. This is independent. Second count. Assuming 287 or 266 apply, there has to be a pre-decisional notice of hearing permitting the person responsible to state his case, explain everything to the commissioner or the person hearing. This is a requirement of statute. This is kindly see 287. This is there in all statutes of similar nature. KMC Act, Howrah Municipal Corporation Act. Please see 287. Please see 266 first. It's absolutely clear. Please come to the proviso of 266 subsection 1. This is similar, in fact, pari materia to 400 subsection 1 proviso. provided that no order of demolition shall be made unless such person has been given by means of a notice served in such manner as the commissioner may think fit, a reasonable opportunity of showing cause why such order shall not be made. The statute gives me the right to persuade him not to make such an order. And I will deal with Mr. Bandopadhyay's submissions of no power to regularize. I will deal with that. I am armed with judgments. My lord has taken, my lord, absolutely, my lord, got the nub of the point. Judicially, that word may is impregnated with a power not to order demolition. From 56 Supreme Court till date, uniform law. The word may appearing in 266(1) and in various other statutes is impregnated with the discretion not to order demolition. This is not regularization. This is not compounding by way of a specific statutory provision. This is not ordering demolition in exercise of the jurisdiction conferred by the word may. Please see, I had, my lord, on the earlier occasion stated that I will place those judgments. Now, this is absolutely settled. The earliest in case was AIR 1956 Supreme Court 110, but I'll not dilate too much. Word may interpreted in a similar municipal statute saying that may does not mean shall. Please come to paragraph 10. Similar may, kindly see paragraph 10. May I just place it, my lord, only briskly, my lord. In this view, the point for decision is whether order passed by the municipal magistrate, which was the authority there under a similar provision of demolition, and affirmed by the learned judge is open to attack on the merits. Respondent contends that the magistrate has under section 363 a discretion whether he should pass an order for demolition or not, and this court should not in appeal interfere with the exercise of that discretion, especially when it has been concurred in by the High Court. Now, the language of section 363 is that the magistrate may, with emphasis, pass an order for demolition of the building, and though the word may might in some context be construed as meaning shall, that is not the sense in which it is used in section 363. Perimeteria with your, my lord, 266. We agree with the respondent that the section 363 does not require that when a building is shown to have been erected without permission or completed otherwise than in accordance with the terms of the permission or in breach of the building rules, an order for its demolition should be made as a matter of course. In our opinion, it does give the magistrate a discretion whether he should or should not pass such an order. That was the construction put in Abdul Samad versus Corporation of Calcutta on section 449 of the Calcutta Municipal Act 1899, which corresponds to section 363 of the present act on language, which is, so far as the present matter is concerned, the same. Yes. This has now been accepted judicially as one of the cornerstones of interpretation. This is an accepted. Therefore, my lord, just without wasting your lordship's time, I'll multiply but not place. I'll just formally cite 2006 volume 8 SCC page 590, Muni Suvrat Swami. Same point arose. The Supreme Court answered it. Paragraph. Kindly bears with me. 351. Paragraph 10. Following Bombay, paragraph 33. I'm sorry. Paragraph 33. 33.
All right.
There also word may.
Let us come to another.
Now,
what is your further?
as far as so therefore, my point of nullity first is 280, the 287 and 266 would not apply. Second is no notice has been given. Show cause notice, which is a mandatory statutory requirement, makes it gullible on 2 counts: statutory ultra vires as well as violation of the principles of natural justice. Result is a nullity. Third, my lord, point which I had given is that the inspection report which was made, it was made in my presence. A notice of inspection was served upon me. It was made in my presence. The parameters are recorded in the report. What I had at what I was denied of, and that no one disagrees that I was not given a copy of the report. What I was denied of is an opportunity to react to the report. For instance, where there is a recording that there is a cantilever projection of so and so and so and so, I can, in my show cause, which I filed before the commissioner, say that it is necessary, otherwise there is a slight tilting. If for that tilting this has gone out, so these technical and factual aspects I can bring on record. This I have been prevented from doing. Now, does the act contain any provision for supply of copy of report? No. But then natural justice has to be read into the statute the moment there is no express bar. This is absolutely settled law. I'll cite not only one judgment. Then Lord, I will not. This is absolutely settled law. Unless excluded by necessary or by express language or necessary implication. In some statutes, they say, don't do this without notice. Here also, removal of encroachers from public property. The commissioner shall without notice remove. This means don't follow natural justice.
Yes.
Now, Lord kindly comes to two things by which my first limb has been sought to be broken. Mr. Shishanno Bandopadhyay points out two provisions of section 403(2)(d) of the West Bengal Municipal Act to say, my plan is now a deemed plan under 263 of this act. This is what he says. Kindly check that provision once again. This provision is not for that purpose at all. Kindly see 403(2)(d). Notwithstanding anything containing subsection 1, Siliguri Municipal Corporation, so and so as the case may be, shall be deemed to have been constituted under this act, and in respect of every such corporation. Now D, every budget passed, loan taken, assessment made, building plan sanctioned, license or permission or sanction granted or issued, or any other similar action taken under the West Bengal Panchayat Act 73, Municipal Act 93, and the host of other acts. Kindly see, and in force immediately before commencement of this act, shall at the date of commencement be deemed to have been passed, taken, etc., under this act. This is similar to section 6 of the General Clauses Act. Why? Because if a plan is sanctioned under a formal municipal act and is in force, if an action has been taken under a formal act and is in force, and that act goes out and a new act comes in, then by a deeming provision, that particular plan is given a lifeblood which it would have lost otherwise. My plan was not in force when this act came into being. This is something which Mr. Bandopadhyay ought to have pointed out, which is erudition, which he has missed. Please see, my lord, my plan is dated. My plan is dated 19th March. Yes. Plan number 1458/02/03, dated 19th March 2003. There is no question of deeming provision entering into 287 and 266.
The entire issue is deviation to the sanction.
Yes, but
so it is an attribute to the sanction.
It's an attribute.
Action comes in terms of 403(2)(d). Then, Mr. Banerjee, whether it needs to be gone into that the plan was of a much prior date, not immediately prior to commencement of this act.
That we lordship would go into this.
Yes. My plan was of 2003.
The deviations which the 266 and 287 make jurisdictional facts for invoking proceedings, those deviations all relate to in presenti actions done during presence of that particular statute. It's a penal statute.
You read in this way. Budget plan, building plan sanction, then you come under West Bengal Municipal Act 1993, ever be deemed to have sanctioned under this act. You just read in this way. Building plan sanction under West Bengal. It is West Bengal.
The Bengal Municipal Act 1993. Fourth line.
West
Fourth
Bengal
line.
Municipal 1993
18.
be deemed to have been sanctioned under this act.
Absolutely brilliant observation from your lordship, but missing one point. When does this act come into play in respect of my premises?
So that 18. Sorry, that date was given in the.
Was that plan enforced then?
My brother says.
No.
That plan.
No, my lord, but absolutely brilliantly exposited, but kindly consider this. I will surrender this point if I am unable to convince your lordship. I will surrender this point. Please kindly look at, my lord, once that provision.
This act came into on 18th of June 2015.
Here, 2015
Plan was of 2003.
expired on 2008. Couldn't have been revalidated beyond 2013. So is it a plan in force?
Where is it said that a plan in force?
Yes, please take out all the please take out all the names of that. That's why I mean, Lord, I tried to hustle up. Please. Every budget pass, loan taken, assessment made, building plan sanctioned, license or permission or sanction, granted or issued, or any other similar action taken under West Bengal Panchayat Act or the West Bengal Act 1993, that's municipal, Shiliguri Municipal, Asansol, Chandanagar, Durgapur, and in force immediately before commencement of this act. Shall. Immediately before commencement of the act to my regime is 2015.
All right.
My lord, this is my answer to Mr. Shishano Bandopadaya's point. This can only be used in a limited Section 6 General Clauses Act situation where there are two back-to-back statutes. One is being repealed by the other. If there is already a plan given there under that act and it is in force, it shall be deemed to be under the new act. Otherwise, it will lose its existence as a legal fiction. Here, my plan has spent its force during the West Bengal Municipal Act regime. Then it has come into this act. The similar Section 6 analogy will not apply in my case. That's my submission. Now I leave it to your lordships. Now kindly look at the other point. The point given by my learned friend, Mr. Chatterjee. Kormokar, I'm so sorry. Mr. Kormokar, kindly look at the Section 383 and what it says.
83.
Yes. He says that there's a saving clause. It saves the pending proceeding. That's what I'm saying from the very beginning. They didn't start a proceeding under the 1993 Act. They did not. Today, they can't now go back and snatch it. Kindly see, my lord, 383(1). Any suit or other legal proceeding instituted or any action taken which, but for the passing of this act, would have been instituted or taken under the Shiliguri, Asansol, Chandanagar,
By or against the corporation.
Durgapur,
May be continued.
by or against the corporation constituted under this act, may be continued or instituted by the corporation. This is speaking of continuation of a proceeding already initiated. Any suit or other legal proceeding instituted or any action taken which but for the passing of this act would have been instituted or taken under the Shiliguri so-and-so acts by or against the corporation constituted under this act may be continued or instituted by the corporation.
Contention is any pending proceeding is saved by this.
Number one, any pending proceeding. And second is, if there is any proceeding which is instituted or taken, both refer to pendency.
Yes.
For the purposes of this subsection, for the purposes of any suit or other legal proceeding referred to in subsection 1 and of all matters incidental thereto, powers and the duties of the councillors, the board of councillors of so and so, so and so, so and so, so and so, these are the corporation, as the case may be, shall vest in the corporation constituted or appointed under this act. This is an age-old principle of saving of proceedings. Gopal Mukherjee versus Kolkata Municipal Corporation, one of the earliest judgments, my lord, at least, my lord, my practice tenure, Mr. Justice Shubhra Kamal Mukherjee, as he then was, Municipal Act, previous Act of 51 has a valuation. This valuation was done under the 51 Act before the Small Causes Court, an appeal lay. Now, what happened when a 51 Act was repealed by the 80 Act? 80 Act gave lifeblood to those proceedings and ensured that they continued as if it was under the new Act. Otherwise, it would have lost its sanctity. When the Premises Tenancy Act of 56 was repealed by the Act of 1997, similarly, a statutory fiction was given that those proceedings under the 56 Act will continue under the 56 Act, untrammeled by the fact that 97 Act has come in. These are provisions to take care of transit and continuance of proceedings which have once been initiated for lack of legal sanction after that act is repealed. It's to create that joint. This does not mean that if you have not initiated a proceeding in respect of a cause of action which arose in the former act, and you have allowed that proceeding uninstituted to remain until the new act has come in, today suddenly you get lifeblood and you say, no, I am for all intents and purposes the municipality, and therefore 30 years ago if someone has made a plan there, it may made a construction there, today I can hit it. This is not the intent, this is not the purpose of this. Purpose is section 6X, 6 of the General Clauses Act.
According to you, your construction was completed?
Has to be within planned period, my lord. 5. According to me, 2005. There were deviations. My friendly neighbor Ganesh Patro came to court 15 times so that he wanted to see debris and concrete and rubble in my house. He came to court 15 times. But by Mr. Patro's incursion to court, none of the legal consequences can change.
Yes.
The learned single judge, my lord, has found a lot against me and in favor of Mr. Patro, saying that the gentleman has had to come to court repeatedly to bang his head here. The learned single judge also ought to have considered that I had complained about the unauthorized construction made by him, which was a floor beside my building. An entire floor unauthorized has been cast. And as a counterblast, now he is banging his head because he also wants to see rubble. That's why I used the expression tit for tat, my lord, yesterday.
Yes, what is your
yes, the next
for the regularization fact?
Yes, this is absolutely clear again. Regularization, my lords.
Said na, that we have no power to regularize.
I agree. You don't have a power to regularize. Power, my lord, there are 3 kinds of condonation of a construction made beyond sanction. Just Ghanshyam Das is per incuriam. I'll show you, lordship, why. I have argued Ghanshyam Das earlier also. Justice Soumitra Pal's judgment, considered to be very high authority, but it's absolutely per incuriam. I'll show you, lordship, why. His lordship was not properly assisted.
Your only answer to this?
Yes, answer is this. There are 3 ways of allowing a deviated construction to remain on the face of the earth when complained of. Way number 1 is called compounding. Your lordship will find it in the Bombay Municipal Act. Compounding up to a certain FAR is compulsory. Even if I deviate beyond and up to 10% of the available FAR, they are bound to regularize it if I pay higher fees. That's called compounding. This is species 1. Species 2 is regularization. It is a cousin of compounding. There they are not bound to do it, but if they have any scheme or any provision in any subordinate legislation or any executive order having the trappings of some parameters, and I fit those parameters, then they can grant me post-constructional sanction. That's regularization. These 2 require express provisions in the statute. I agree with my learned friend wholeheartedly. Express provisions of the statute. The third one is retention or non-ordering of demolition. That's exactly what has been done in this case. That or non-ordering of demolition. This retention, the power to retain or not to order demolish, is an outcome of the discretion injected by the word may. If I can satisfy the commissioner, I have been given a right to show cause. My lord, no legislature ever gives a right to show cause in vain. I have a right to show cause why an order of demolition shall not be made. If my cause is satisfactory to the commissioner, to the hearing authority,
Sir did not file the written objection as directed in 2014.
against
2014 Justice Pal's order,
in
written objection to be filed.
in this action, there is no action.
No. Come to the
My
order.
lord,
of justice.
yes, kindly, my lord.
Page 41.
Yes.
They would be at liberty to file written objection to the complaint, and the board of directors shall pass a written.
My lord is looking at the 6th August 2014 order. 6th August 2014 order, my lord, is not the genesis of this proceeding at all. Kindly see what the 6th August 2014 order was on whom. Kindly, I am asking myself the question. It was in connection with a different inspection, and it was on the municipality, not the BMC. How can they take this order in support of what the BMC has done 5 years down the line? No, please check the facts, my lord. I may be wrong. 6th August 2014 order was an order of Justice Pal directing the West.
Order placed by you first. You showed us.
No, I had to, because this is an order which was there in the train of things. This order says
Private respondents are at liberty to file written objection.
yes. To which inspection? I'm asking myself.
Inspection, it is liberty to file objection to the complaint lodged.
No, please see.
At the
Please
time of
see.
hearing.
Please
There is
see.
no inquiry here.
Please see here. Not after granting an objection. Please come to page 41. Please bear with me. Lord. Come to page 41. Kindly see, having heard learned advocates, writ petition is disposed of by directing Board of Councillors of Rajarhat Gopalpur Municipality to initiate proceeding under section 218 within a fortnight from the date of presentation of a copy of the certified copy of this order, and shall conclude the same within 8 weeks after giving an opportunity of hearing to the petitioner and the private respondent numbers 6 and 7, and after verifying the records, including the sanction plan, if any, and after causing an inspection of the site upon notice to the parties. At the time of hearing, the private respondents are at liberty to file written objection to the complaint dated 3rd December 2013, and the Board of Councillors in its reasoned order shall deal with the same.
Has continued. This has continued. You said your arguments were.
This cannot be done, etc. Now kindly say, assume that for the Board of Councillors, there is.
We are asking, is there a liberty to file written objection?
There is a liberty to file written objection at the hearing before the Board of Councillors, which never took place.
Yes.
Second, had I been, I'm sorry.
Your argument is there was no hearing.
Where will I file?
All right.
I couldn't have done it before the Board of Councillors because they didn't hear me. I couldn't have done it before the Municipal Commissioner because he didn't hear me. And he says that hearing is not necessary. Why? I'll show you, Lordship. Sometimes, my Lord, excuses on questions of law become absurd when it is taken into this amount of facts. Why is no hearing required under 287? Why is no hearing? My Lord, hearing is not required because, please see, my Lord, page 45. Because they gave me a notice of inspection. Their contention is, I gave you a notice of inspection when I went to your house. Both parties were present. Therefore, after that inspection is held, you are an outsider to the act.
Understood. Your point we understood.
Therefore, all these cause nullities. And how do I get around 23 Rule 1? Sarguja, my Lord, I argued in vain before Justice Dipankar Dotto in my fledgling days in the profession in a matter called Randelia versus Kolkata Municipal Corporation. 23 Rule 1 squarely applies in all conditions. Writ versus writ.
What applies?
My Lord,
What applies?
Order 23 Rule 1 squarely applies in writ versus writ versus suit, and suit versus suit. As in, if an earlier suit is filed and you withdraw it without liberty, you can't file a writ. It applies. I'm not on that. That's why I'm saying, if it is a nullity, your Lordship does not.
Same that also because we are exercising plenary power.
Yes.
Even if it is there, it can be ignored and the matter.
One, secondly, and
Cases where there is violation
of the principles of natural justice, fundamental rights. And fundamental right, Article 14, natural justice.
that you have argued.
Natural justice, Article 14. This, secondly,
Repetition cannot be there. Read versus read, should versus should, but in cases where where the fundamental right infringement is there, the read court having plenary power can go into
that question.
That is what you
That was my argument on the earlier question.
Thank you.
I leave it to your lordship.
Learned advocate. Judgment.
Lord, kindly extend the interim order till delivery of judgment.
Past. Extended the date of delivery of judgment.
Obliged, your lordship. Grateful, my lord, to your lordship, Lord, for a patient hearing. I again apologize if I have been repetitive yesterday.
Wait, sir. We are already at 440.
No, it's 440 P. Was scared. He thought 440 volts.
Supervises, making a prayer item number 270 of the common list. This matter relates to employees of Calcutta High Court service matter.
My lord, I appear for the respondent. This is required to be released because my lords are not having the determination.
70, any other party is there?
No, no, no. I am the respondent.
Is the answering respondent, my lord.
All the respondents.
Yes.
এটাকে তুলে কালকে ডিভিশন দিবি 70 এটাকে তুলে similar
Obliged.